Circumstances are mentioning a matter, not in the list. I'm not.
It will appear on Monday in the combined list.
Monday.
Not top. It will appear as per CDLT, Mr. Mukherjee. First, let it appear first. ওটা নিয়ে নিয়েছিল তো?
Lordship. Lordship.
Still give the slip. Combined list দিয়ে দিও. Yes, call the list.
But in this matter, I am appearing for respondent led by Shiv Shankar Banerjee. My lord, he is online. He is online, Mr. Banerjee, and I am relying upon two documents. Through such documents, my lord, it is a fraud case. In this matter, I am praying to fix the matter on 10th. Your lordship, I have communicated evening there. Yesterday evening, I have communicated him.
No, 10th we cannot hear because my brother won't be there. It has to be heard by my brother also.
Yes, lordship.
Because we passed an order.
Lordship, then next week.
Next week it won't be possible. We will retain it as a part-heard matter after.
Lordship.
Lordship, the order may be uploaded in the meantime. Because this cannot go on, my lord. From September 2022, they are not appearing. Peremptory direction was there to file opposition.
I understand. Suppose today we cannot take it up. In that case, my brother won't be here. He has substantially heard the matter.
The matter can be taken up today itself. Because order was passed, my lord. They didn't appear, matter was appeared.
I am relying some documents by affidavit. I have already served upon them.
What affidavit you are giving?
This is a fraud case. Land was in fraud. Mr. Goenka, Ramaprasad Goenka, died on 1970. And they purchased the land on 2000. Deed is of 2002.
You have got a copy?
Yes,
Lordship, that is not an affidavit.
yes, lordship.
Let me tell you, lordship, what happened.
I am submitting.
Before this honorable single judge, they filed an affidavit. These points were not taken. Now order was passed. They didn't carry it in appeal. We carried it. Lordship made a simple modification that in the case ECL finds that similarly placed persons have been provided with employment, I should be provided as well. This is the only modification. They didn't file any opposition here as well. So no question of any order 41, rule 27 as well. Now they are coming with certain documents, additional documents after the appeal has been dismissed, disposed. Is it tenable in the eye of law?
The subsequent discovery.
That fraud has been happening in this matter.
Listen, we cannot, he's right. We cannot accept any further documents at this stage.
Madam, this is a fraud.
You did not argue before the writ court. You did not argue fraud.
Your lordship, kindly make it after vacation and as part heard, Madam Lordship.
Why he shall suffer? We passed the order.
My lord,
it was
very-
his benevolence that he came and said that all right. Here.
My lord, today is the situation. Mr. Banerjee is not here. He is online.
Lordship, let me submit only one thing.
आगे order टेक
To land.
You are Mr.
Devo.
Strategy.
Mr. Chatterjee, there was an earlier direction
Matter
towards
land
him,
user.
My lord.
Justice Talukdar.
Yes. Peremptory direction was passed on 2 or 3 occasions.
We are not taking it on record.
My lord.
It has been given to you. You keep a reply ready. We heard the matter finally. We will consider your objection and then we will entertain that.
But the appeal is disposed. It was dictated in the open court.
We recalled that and fixed it at to be mentioned. Why don't you understand?
But it was recalled when
Mr. Banerjee was there.
Yes.
Recalled in the sense we kept it for rehearing. It was understood that we will not upload the order.
No, but this thing, my lord, this petitioner is being prejudiced. Kindly appreciate the state of the petitioner. Since 2022 September, this is going on. Matter was hard for entire 1 hour. Entire 1 hour matter was hard. They didn't come. Now when the appeal is disposed, they were the fence sitters and they appeared before your lordship.
কি বন্ধ হচ্ছে না?
Where is Mr. Banerjee?
Mr. Banerjee is at Delhi now.
Huh?
Today at Delhi.
And he could have appeared by online as well.
আসুন। Today an adjournment has been prayed for on behalf of the respondent numbers.
Next several numbers, Eastern Coalfields Limited,
Though Mr. Chatterjee, learned advocate appearing for the
1 to
appellants,
5.
Huh?
1 to 5.
1 to 5 is present. Stop. As a last chance, the matter stands adjourned. Stop. Is the matter in the daily supplementary list of this court under the heading to be mentioned on on 22nd November. Release on 22nd November. Stop. The matter shall be treated as hard in part. Yes.
Very much obliged.
Actually, but was the order recalled, my lord? Was the order recalled, my lord?
Not signed the order. We have not signed the order.
And they kindly appreciate the entire exercise for 1 hour is a futile
We
exercise.
consider your case. We have kept it part hard.
My lord, my application may be kept.
Sorry, that we cannot take it at this moment. এটা ওনাকে ফেরত দিয়ে দাও। Affidavit ফেরত দিয়ে দাও।
Kindly looks at the conduct of the PCL. 2022, they are being fence sitters. And now for entire 1 hour, the judicial time is wasted. Now they come up and again pray for adjournment. Heavy cost must be imposed for that.
Where is Mr. Banerjee?
ও দিল্লি
Mr. Banerjee is appearing. He's coming. Mr. Shutartha Banerjee. Shivshankar Banerjee is, I'm told that, out of Kolkata.
সিদ্ধার্থ ব্যানার্জি।
He's engaged. He's coming. Report 5. But cost must be imposed upon them because I am will, my lord, going on pillar to post.
সিনিয়র একটা কথা সিনিয়র একটা কথা বলছে জুনিয়র
Mhm.
সিনিয়র সঙ্গে আপনি
And Mr. Banerjee is here.
after revision part
Mr. Banerjee, we have not accepted the opposition which they have prepared and brought it. But our predicament is my brother won't be there from Monday. So this bench will break. It cannot, this bench won't be sitting in all probability prior to the vacation. We have kept it on 22nd as a part hard so that we can discuss it. Your junior is insisting that we should take it up today. We understand.
Yes,
He's not, but the application, it was prepared on his part respond to your senior's call and come and tell us,
Lordship,
because he would be suffering. When we passed an order, it was on your mutual request. So this conduct is not appreciated.
And I tell you,
Lordship,
Lordship,
He
that
may
was-
be a senior counsel. We are not concerned with that. He took the opportunity. Matter went down as a fixed matter. It went out of our notice. It was pointed out. We kept it. Now you say that my senior is not there. So he might not have responded to your senior's.
my lord, yesterday I was present here upon receiving notice that the matter
This
is
is
be
not
mentioned.
here.
They were not here.
My lord,
Yesterday.
my lord, may I be permitted to appear virtually, my lord?
We do
My
not
lord,
have your stand.
I'm very sorry. I'm
Sorry.
very sorry, my lord. My lord, what happened with me is,
We are
Lordship,
sorry, we won't hear you.
I'm extremely sorry, my lord. I tender my
You take the time. It is his benevolence that he responded, and now when it is here, you go off to Delhi and you shoot to say that I will argue. This
saying
is
is,
not only one matter. It is
I know.
fairness of the council, which
I
we are
know.
concerned about. If you had
Lordship,
Delhi, why didn't you come yesterday and tell us that
Lordship, in the morning, yes, morning I was there.
First-
Lordship. Morning first half, we were there. They could not mention at the first half. They only mentioned at 1
So
p.m.
please
First half,
don't
we
take
have
advantage of that.
no,
Please
Lordship. I will not. I will never do that. Lordship, I am the last man to take like that. I'm very sorry, Lordship. This will never repeat in
This
this.
had never been the culture of our court.
Lordship,
Institution for more than 20 years.
Lordship, I know, Lordship. Lordship, this is for in a compelling circumstances, I had to come out of station, Lordship. Lordship, the only issue here is I would like to file a bunch of document by way of an affidavit.
We have not accepted your documents. We have not accepted.
Lordship, by that document, we only want to show the deed which he executed in his favor from a person. That person was not alive and he was missing.
My lords, item number 2 is probably appearing in the list at my instance, your lordship, for corrections. Your lordship, what has happened is in MAT number 1329 of 2022, your lordships were pleased to pass an order on 23rd of August.
Hmm.
Unfortunately, your lordship, due to some inadvertence,
What has happened?
the case number, if your lordship sees, it's come as FMA 1329 of 2022.
Hmm.
As a result, your lordship, the matter has been tagged with Shukdev Patra versus State of West Bengal. If I may present the case status, your lordship, of 1329 MAT.
Yes. What is the mistake?
Lordship, the case number.
What
The
is
case number was MAT 1329 of
not
2000.
FMA 13?
No, my. Because of this, this matter has gone into purgatory and it is not appearing in the list at all. Because this has been confused. If your lordship kindly sees on top, MAT registration number 1329,
What about
we have
that?
controlled the delay
my lord.
and we have treated
Directed
it as
to be
ready
a-
for hearing. We have fixed it in September month.
My lord.
It is appearing.
My lord, what has happened is if your lordship sees straight on top, it says FMA 1329 of 2022.
Understand, but is the correct matter appearing in the list?
Correct matter is appearing, your lordship.
What is the item number?
Monthly list, your lordship, it was appearing.
It was appearing.
It was appearing, your lordship. Now it is difficult for me to say whether it was appearing in its own capacity or whether it was appearing in disguise of this matter.
We will correct it. এটা যদি থেকে থাকে এমএটু যদি থেকে থাকে লিস্টে চেক করে নেবে
আর সেটাকে
by reason of a typographical error in the cost item. By reason of a typographical error, cost item of the order dated 23rd August 2023, comma, the number of the it is MAT.
MAT, my lord.
It is against an order passed by, it is a mandamus appeal. Oh. As a legal upon by the time the cost title of the order dated and the number of the matter has been erroneous has been incorporated as quote unquote FMA 139 of 2022 in place and instead of MAT quote unquote MAT 1329 of 20. Microsoft Office is directed to effect necessary action. It will be
My lords may appear in the October monthly list, if your lordship. Grateful.
Please take the
Item 3, my lord, this is my application, my lord. My lord, the child has lost his father, my lord, during the order of my lord has at page 13, my lord. My lord, the child
number হচ্ছে habeas corpus item number 3 I guess
application arising out of habeas corpus. Another
yes
the child has lost his father, my lord.
what is
during
the application for
Application
modification
for my lord, what is the mental health of the child, my lord, at the hospital.
have you served
that-
this application
It is not sir, my lord, I have no praying, I have not praying, my lord, any interim protection, my lord. May I serve and come?
no what modification you want
Modification, my lord, prayer is, my lord, to appoint a special team to inquire the mental health of the child, my lord.
why you are not getting visitation right we
No.
have given you visitation right
Visiting right, but page 5 he's saying para 4 and 5, my lord.
yes what is
Child direction, honorable court, most occasion child is not available due to negligence of the petitioner. She was already further married and she is residing with his new husband, my lord. This is the
you don't understand what modification you are wanting
my lord. Paternal grandfather is praying, my lord, to change the custody because the mother has married again, my lord. Now, child, as per direction of a lordship, child is under the custody of mother, but mother again married, my lord. And now she is residing in the new.
Who is the
matrimony.
petitioner?
Petitioner is the paternal mother and grandfather.
the petitioner is directed to serve copy of the application being can 1 of 2023 upon all the respondents intimating that the matter will be taken up for further consideration on 28th November. Stop.
28th November. Grateful.
Sir,
Please team. Argue. It is on and to file an affidavit of service on the returnable stock. List the matter, accordingly, on 28th November 20.
Grateful. Very good.
Madam, to appear for the petitioner.
My Lordship, in this matter, Miss Amrita Baja Mollik is appearing for the state. She is engaged in courtroom number 6. My Lordship, I'm praying for a short passover.
My lord, the girl has been kidnapped. Your lordships, my lord, may remember, my lord, for refreshment of your lordships, my lord. Sikkim, my lord, Sikkim, and my lord, my lord.
Wait for my Lordship.
5 minutes and for the Union of India, Lordship.
Who is for the petitioner?
My lord, Mr. Shondipon Ganguly is appearing on behalf of the petitioner. I'm kindly praying a short passover, my lord.
Detained under the Cafe Posa, my lord.
Short passover, my lord. He's engaged in courtroom number 28.
Well, Mr. Ganguly is appearing. Shondipon Ganguly is appearing. Lord, kindly grant me a short passover. He's in court number 28. Kindly grant me a short passover. May I say one thing, my lordship? But it is detained under the Cafe Posa, my lord. Huge amount is it.
We will hear you.
My lord.
Item number 6, my lord, I am for the petition. Last occasion, my lord, your lordship directed me to serve the notice, and there is specific order of the court that BSNL should submit a report. And my lord, this report till today, the report has not been submitted. This is the case, my lord, where weightage mass has not been given for accommodation.
Why he is not appearing?
That I do not know, my lord. Report, my lord, different report is submitted. And my lord, I am staying in a rented house and I'm entitled to get at least 10 marks, my lord. If I get 5 marks, then my lord, I could have get appointment on a compassionate ground, my lord. And your lordship, kindly see the order passed by the AGM BSNL, my lord, that 87 and 88, my lord, the chart is given.
Who is the competent officer?
That is AGM R&E BSNL.
No, who conducted the inquiry?
The inquiry was conducted, my lord, that is page SDT administration. 2 inquiry report was submitted. One, my lord, page 104, that is the administration, Calcutta telephone, and another is, my lord, this page 101. It is, my lord, JTC welfare BSNL Calcutta telephones. And my lord, 2 different order is passed. Inquiry report is 2 different. And my lord, they have.
Why he is not appearing? Shantanu Chatterjee.
Yes.
Mr. Bodua come at 1 o'clock.
Yes.
Send him an intimation to come before us.
Yes, I am deeply
Ask him to be here.
Yes, I am deeply obliged.
একটা সময়
একটা সময় তুমি একটা চিঠি দিয়ে দাও তো আমার। হ্যাঁ, একটা সময় হবে।
Mr. Borua, take back your notice. Yes, that.
Last order, my lord.
Take your seat, take your seat. Mr. Borua, please show us the writ court order against which you have. Tribunal order. Tribunal
Order
order.
of tribunal order of the tribunal.
Page.
That is, my lord, the page 111. And then a relevant question is, my lord, the page, my last annexation, my lord, page 111, 5/2023.
Hmm.
Dismiss the application on the part of, on the ground of laches. Delay.
Yes, give us the report.
Report given option, my lord.
Have you given copies to Mr. Borua?
No. My lord. Okay, active copy আছে.
দেখি রিপোর্টটা দাও।
They have not served any copy to me.
Since there was
You
no,
have not.
no, since there was no specific instruction, direction, my lord, from your lordships and my lord, though I sincerely pray for apology for the. Starts from page 9, my lord.
Mr. Borua, go through this and come back.
And my lord,
You go through this. If you wish to use an exception, you use.
I will, my lord, use the exception because I do not know what.
All right. Mr. Chakraborty, learned advocate for the respondents, has filed a report in the form of an affidavit. Stop. Let the same be kept on record. Stop. A copy of the same has been handed over to Mr. Borua, learned advocate affiliated for the petitioners in court today. Stop. He prays for stop. he pressed for leave to file an exception. He said, stop. Let such exception be filed within 2 weeks.
Within 2 weeks, my lord. Within a week, my lord. I will sub the copy within a week.
Within 2 weeks, stop. List the matter under the same heading in the daily supplementary list of this court on 17th November.
17th November. My lord, instead of 17th November, my lord, your lordship kindly see, my lord, the other 22nd November, because my lord, I was 22nd.
22nd, all right. 22nd.
22nd November. I am deeply obliged.
22nd. Yes.
I am deeply obliged.
Lord, 7, my lord, I am for the petitioner, my lord. On last occasion, your lordship was directed me to serve upon the learned advocate and file the affidavit of service, my lord. Mr. Gupta is today appearing, my lord. My lord, the matter is related to the compassionate appointment of a BSNL employee, my lord. My lord, he died in the year of 2000 on 24th of December 2000. And my lord, immediately thereafter, his wife applied, my lord, on 19th of February 2001. And thereafter, the concerned authority of the BSNL direct to form a committee to find out my financial position and whatever the condition of my house regarding those. But my lord, unfortunately, they have not find out my house, my lord. Ultimately, my application was rejected. Challenging that, my lord, I preferred an application before the learned tribunal. Learned tribunal directed that to consider afresh by setting aside that earlier rejection order. My lord, thereafter, they formed a 4-man committee to consider my case and to consider also the financial consider what is my house, what is the condition of that. Again,
You are the son.
yes, my lord. Here, before your lordship, mother is the petitioner number 1 and son is the petitioner number 2. And my lord, again, same thing was happened. That they have not find out my house. Challenging that, my lord, I have again second application filed before the learned tribunal. But the learned tribunal rejected my application on the ground that was delayed more than 20 years. And my lord, there is a scheme that is.
You have annexed the replies and everything annexed to this.
Yes. Yes.
There is no scope for any interim order, Mr. Ghosh.
My lord, what I am saying, my lord,
Yes.
there is a scheme, my lord, that is the weightage point system. And my lord, if any person is get more than 55 or more than, that case is to be considered fresh. My lord, never my case was considered according to the scheme. In a cryptic order, my lord, whatever earlier passed, same is again passed, that my house was not found out.
Where do you reside? Where do you reside then?
My lord, at present, I am residing,
Why
my
did
lord,
you say
that
that they could not find the house?
I don't know, my lord.
Must be knowing,
Huh?
there must be some reason. Where are you residing?
My lord, that is at Newtown, Kolkata, my lord. Hathiara, my lord, police station, Newtown, Kolkata. And this is my present address. আপনি এখন কোথায়? হাতিয়া পেছনে দাঁড়াবো ওখানে ওদিকে। My lord, kindly come to that weightage point system.
Come to that later. You said that first they did not find the house, that is why they rejected. Show us that order.
Yes. My lord, kindly come to the page 38, my lord.
You first kindly come to page 4 of the order.
Page impugned order.
Yes. Your case was rejected. Forward to Winton High Power Committee rejected the prayer of applicant number 2, order dated such and such, primarily on the ground that his family pensions did not conclude in a penal condition. Where is that your house was not found?
My lord, I don't know, my lord, whether they really
You tell us your submission is there was a direction that they must conduct an inquiry and file a report
yes,
as regards my condition,
Yes.
but they did not go to my,
yes,
they
yes.
did not find my house.
They did not find.
Where is that finding in the order? That they said they went there, no house was there.
Yes, my lord. My lord, kindly come to the page 38, my lord.
It's 38.
Page 38.
38. That is before
My
passing.
lord, that
this
is the
order.
order dated 26th of May 2020.
That is
My
before
lord,
passing. this order.
in connection with the above reference, it is hereby intimate that the certified copy of such and such, my lord, then in accordance with the said order, an inquiry was a view of offer opportunity of the applicant.
So what, where you
Order or inquiry was conducted by a team of 4 members.
from the top in connection with the above reference, where read.
Oh, yes, ma'am. In connection with the above reference, it is hereby intimated that the certified copy of the order by number way number 50 of 2013 dated 38/2019 was passed by the Honorable CAT Kolkata. The said order was communicated by Sri Anil Kumar Gupta, learned advocate for the respondent, and it was certified to be true on 6/9/2019. The Honorable CAT ordered to conduct an inquiry and pass an order. In accordance with the said order, an inquiry was conducted by a team of 4 members who could not search out the residential address despite best effort. With a view to offer opportunity to the applicant side, a letter was sent through the speed post to the address recorded to the above way so that the financial condition of the family can be ascertained, but the letter was written with the comment no such person, hence not known. Thereafter, final order was passed on the basis of the available record and sent to the address of both Kalabati Devi and Subhas Prasad. The applicant, both the letter was written with the following comments: insufficient address, hence not known. Address could not be located, hence not known. Under the aforesaid facts and circumstances through the speaking order was issued by the competent under the aforesaid facts and speaking order by the competent authority concerned, but the same remains undelivered. The entire responsibility of providing such a misleading address lies with the applicant. Now, once again, a copy of the said order is forwarded herewith.
Where is that?
My lord, then come to the next page, my lord. That is the order, my lord. 14 November 2019, my lord. In introduction, the original application was filed and moved by one Srimati Kalabati Devi being applicant number 1 and Sri Subhas Prasad applicant number 2 before the Honorable Central Administrative Tribunal, Calcutta Bench for relief
Ordered of
content in the application. The application was registered being way number such and such. The order was passed by CAT Calcutta Bench along with one copy, leaving behind being served upon the respondent number 4, that is the Chief General Manager, Telecom Factory, Alipur, Bharat Sanchar Nigam Limited, address such and such, by Pradeep Das, son of late Amol Das, respondent number 2, along with the application received on 28 March 2019. For bearing every regards, for solemn order passed by the Honorable Member Judicial on the bench on 30 January 2019, which was served upon the Telecom Factory, Alipur. The undersigned, being the Chief General Manager, Telecom Factory, Kolkata, has gone through the inquiry to ascertain the financial condition of the late Shambhu Prasad, ex-employee. The principal issue is the compassionate appointment in terms of the order passed by the Honorable Administrative Member of CAT Calcutta Bench dated 30 January 2019. On the basis of an... Yes, madam.
What is your answer? They went to the address given in the original application. They did not find your
Madam, after that, madam, actually they were
যদি কন্ডিশন নয় আর ও বিএসএনএল এর কর্মী নয়, ও হচ্ছে টেলিকম ফ্যাক্টরি। BSNL এর কর্মী
Actually, my lord, they were residing.
টেলিকম
Where is the order of 30th January 2019 of the tribunal?
My lord, page 55, my lord. That is, my lord, the first order. Page 55 is the first order of the learned tribunal. That is 30th August 2019, page 55.
This was your first original application. In 2019, order was passed.
Yes, my lord.
So you died in
And
heart.
my app,
2000.
2013.
What did you do for 19 years?
2000.
My lord, that I have filed the application, my lord, in
2030.
2013,
Your father died in 2000.
2000.
2000.
So you have approached the tribunal more than a
My lord,
decade.
I have approached before the authority 2001, my lord. December died, 2000 December died. I have applied, my lord, on February 2001.
Why didn't you come earlier?
My lord, my thereafter various correspondence, ultimately my application was rejected, my lord, 2012. Then I have applied.
2012 rejected. Where is 2012
Yes,
order?
ma'am.
It was earlier rejected in 2010.
2010, my lord, page 166.
2000 অ্যাপ্লিকেশনটা কোথায়?
And for a moment, my lord, kindly come to the page 212, my lord. My lord.
So, Mr. Ghosh, it has been found that your family is not in a penniless condition and the need has died away since 23 years have passed. This is the sole substance of the.
Yes, ma'am.
Now you tell us what is the wrong in calculation of your condition, financial condition they have considered on the basis of their record.
Yes, my lord. Grateful.
So then
Grateful, my lord. My lord, kindly for a moment, kindly come to the page 212, my lord. My lord, my case was considered according to the scheme of 1998.
you have not taken this point. Your
Yes, my
point
lord.
was
Why, my lord?
restrict yourself to the
Yes.
argument.
My lord, kindly then consider, my lord, the scheme of weightage point system. According to that scheme, my lord, my point is 87.
Where is the reply and opposition are annexed here?
Yes, my lord.
Reply rejoinder to the original
Yes,
application is
yes,
annexed.
yes. I have annexed.
So the
My lord, for a moment, my lord, kindly consider
come
the
after, it has to be for final hearing. There is no scope for any interim order.
my lord, my only prayer is, my lord, kindly directed the authority to consider my case according to the weightage point system. My case was never considered according.
Absolutely wrong.
My lord,
Absolutely wrong.
actually,
The present appeal.
On the basis
And
of apex court,
my lord, kindly,
judgment delivered.
my lord, for a moment, my lord, kindly consider the very recent decision.
We will hear you, sir. We will hear you. We are fixing it for you. The present petition has been preferred, challenging an order dated 21st of June 2022, passed in an original application being OA 350/0108/2020. Stop. Mr. Ghosh, learned advocate appearing. Heard Mr. Ghosh, learned advocate appearing for the petitioner, and Mr. Gupta, learned advocate appearing for the respondents. Stop. We have been informed that the writ petition was decided upon exchange of reply and rejoinder, and the pleadings and documents. Reply and rejoinder. Stop. The pleadings and documents are all pleadings and all documents upon which reliance was placed before the learned tribunal are already on record. Stop. In view thereof, dispensing with the formalities, the matter is treated as ready for hearing. Stop. List the matter accordingly in the for hearing in the supplementary list of this court on 11th December. Yes.
And my lord, may I pray one thing, my lord? According to that scheme, my lord, my point is 87. But
We
that,
will hear that.
yes,
Otherwise,
no, my lord. What I'm praying, my lord, but that point is not stated in this writ petition, my lord. So, my lord,
which point?
that my point is 87. According to my calculation, that is not stated in the writ petition. So, my lord, kindly give me a liberty to file a, my lord, just 4 lines supplementary affidavit, my lord. By only stating that my point is 87 according to that
Cannot be,
scheme, my lord.
At the lower, he has already filed original application. No point has been taken this. And thereafter reply rejoinder already been taken out. Not a point this has been taken. And apex court, my lord, already held. After 23 years, this cannot be
Why you
considered.
are so unkind, Mr.
My lord, kindly latest judgment, my lord, knows better than me, my lord.
Right.
My lord knows better than me, my lord.
So, if first paragraph to recall. No, Mr. Ghosh, learned advocate appearing for the petitioner is for leave to file a supplementary affidavit. So, let's a supplementary affidavit be filed within 2 weeks with a copy to Mr. Gupta, learned advocate appearing for the response. So, list the matter for further consideration. 11 December.
My lord, when before
No, on 7th December. 7th December. Yes.
7 December.
17th of this
7th December.
7th December.
7 December.
Yes.
Only two.
Good.
For the petitions. My lord, the original applicant, my lord, before the learned tribunal. My lord, here's the affidavit of service, my lord.
Where is your other side, Mr. Roy?
My lord, previous occasion also, my lord, did not turn up, my lord. I have served on by hand 25th of September. And my lord, this.
We are passing it over. We have to.
As your lordship. As your lordship.
Pass over matter.
Only, my lord, this matter. Grateful, my lord. Oh, sorry.
মাঝামাঝি লিখেছে
I bring for the petitioner. This petitioner, he is the brother-in-law of the detainee by the name of Sheikh Sirajul Haq. Now, in course of a inquiry which was conducted by the Customs Authority, on the 26th of March 2023, 4 persons were arrested by the Customs Authority near the airport. The detainee is not one of them. On the 26th, these 4 persons were also produced before the learned magistrate, the jurisdictional magistrate. Thereafter, in course of the inquiry, my name purportedly transpired, and I was arrested in connection with the customs case, which is under 135 of the Customs Act, on 22nd of May 2023.
You are Sirajul.
I am, yes, Sirajul Haq, Sheikh Sirajul Haq.
Alias Azad.
Yes, my lord.
You were subsequently arrested and produced.
Yes, I was subsequently arrested on the 22nd of May 2023, and I was produced before the learned jurisdictional magistrate. I was also granted bail on the 20th of July 2023. Thereafter, on the 25th of July 2023, I received a summons from the Customs Authority. I went over there. I was threatened to make certain self-implicating statements, but anyway, I filed also I've affirmed an affidavit to that effect. Thereafter, on the issue which is here, this date is very important. On 19th of September 2023, the Sirajul was arrested from his residence and was thereafter consigned to the correctional home. He was handed over a copy of the order, which is at page 65. This is an order dated 5th of September 2023, thereby directing my detention in connection with the Kofeposa Act.
Yes.
Now, if your lordship kindly sees section 3, subsection 3 of the Kofeposa Act. এটা দুটো আছে।
Earlier arrest was in respect
Of the
state.
Customs Act, a prosecution, a criminal prosecution.
Case number?
Malad,
Case
55,
number?
Customs case 55. Malad, the order your lordship will get at page 61. My bail order.
What is the case number?
Well, it would be miss case number 55 of 2023. Page 61, your lordship will get it. It's written as 2020, but it, I think, subject to correct.
This is in connection with which case?
Which case?
Well, which one?
Whether in case in
Kofeposa proceeding is a detention, preventive detention.
Brother wants to know whether the previous arrest was under the self-same procedure.
No. It was under a prosecution under section 135 of the Customs Act. The remand application your lordship will get at page 31. The initial remand application. This was with regard to an allegation of smuggling from outside in respect of gold. They were detained at the airport on 26th. Nothing was recovered from them. On the basis of their statements, search and seizure were conducted in two places. Malad, from there, gold was recovered along with
Customs.
that is with regard to the 135, section 135 of the Customs Act.
Hmm. Yes, now.
Now, I was arrested in that case. I was granted bail. After that, Millard, on the 19th of September 2023, I was detained in terms of the detention order, which is at page 65.
Allegation is different. On earlier occasion, on the allegation related to gold.
Millard.
Now here allegation related to smuggle of goods,
Smuggled goods.
and concealing smuggled goods in future.
Now, if your lordship,
Challenging the 5th September order.
my lord, I'm
Yes.
challenging the entire proceeding to the extent that, my lord, if your lordship now kindly sees section 3, subsection 3, section 3, subsection 3 of that,
Just.
of the Kofeposa Act. My lord, I've given 2 copies.
এই আরেকটু
এই দুটো বই দিয়েছিলাম তো। দুটো বই দিলাম তো।
Yes.
My lord, if your lordship kindly sees section 3, the central government or the state government or any officer of the central government not below the rank of a joint secretary to that government, specially empowered for the purposes of this section by that government or any officer of the not below the rank specially empowered, may, if satisfied with respect to any person, including a foreigner, that with a view to preventing him from acting in any manner prejudicial to the conservation or augmentation of foreign exchange, or with a view to preventing him from smuggling goods or abetting the smuggling of goods, or engaging in transporting or concealing or keeping smuggling goods, or dealing in smuggled goods otherwise than by engaging in transporting or concealing or keeping smuggled goods, or harboring persons engaged in smuggling goods or in abetting smuggling of goods, it is necessary so to do, make an order directing that such person be detained. Then provided that, well, this does not relate to us, then subsection 2 also does not relate to us. Kindly see subsection 3. For the purposes of clause 5 of article 22 of the Constitution, the communication to a person detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after the detention, but ordinarily not later than 5 days, and in exceptional circumstances and for reasons to be recorded in writing, not later than 15 days from the date of detention. So it really provides for 3 eventualities. One is that it should be the grounds of detention along with the documents relied thereon should be made as soon as maybe after the detention, and ordinarily not later than 5 days, and in exceptional circumstances and for reasons to be recorded in writing within 15 days. Millard,
From the date of detention.
detention. My date of detention is on the 9th. Millard, 5 days therefrom would be 14th. And 15 days even, if we take it, it would be on the 4th of September or 4th of October. Now, so far as our instructions go, my lord, this was filed before this honorable court on the 3rd. Till that date, there had been no service conducted. Well, so far as our instructions go,
Get this order. 65.
well,
This was
this,
not communicated to you.
this is only the detention order. The grounds of detention is a separate, my lord, if your lordship kindly sees again subsection 3. My lord, the communication to a person detained in pursuance of a detention order of the grounds on which the order has been made.
Yes, with a view to prevent him from smuggling goods, abetting smuggling goods and engaging in transporting and concealation. Is the ground, do the ground come in a separate order?
Yes, my lord, it does. Along with the documents which are being relied upon in the said grounds.
Where do we find that? That the detention order must be accompanied
Well,
with the
if your
grounds
lordship,
Constitution 22.
my lord, if your lordship kindly sees Article 22, sub-article 5. একটা আছে কখন? আছে? এই যে না রে, একটু একটা extra copy. Well,
Yes. Authority making the order shall, so soon as may be, communicate to such person the grounds on which the
order has been made and shall afford him the earliest opportunity of making a representation against that order. Now, therefore, this is a
There is the provision, Mr. Ganguly, that the detention order must be accompanied with a grounds.
It is not to be accompanied with it.
so therefore, according to them, there is a separate document which reflects the grounds. This is the order of detention. The grounds on which this order of detention is
Where is the procedure, Mr. Ganguly, that it has to be with all documents and
Yes. And a
well,
separate-
that your lordship will get in the judgment
communication,
minutes.
separate order, it needs to be passed, and separately it is to be communicated to the.
Well, that your lordship will get in this judgment, which
My
is
lord.
reported in AIR 2009 Supreme Court, page 2184. AIR 2009 Supreme Court 2184.
Supreme Court. No, 2009 Supreme Court. 2184.
Well, because the grounds are to be given only after my detention. The order is passed after my detention, the grounds are to be communicated. There is no requirement for communication of the grounds relating to that which impelled them to issue that detention order prior to the issuance, prior to my detention.
how does this judgment help you?
Well, if your lordship kindly sees,
Which paragraph?
There are 6 table.
kindly sees paragraph 6. Well, it kindly gives me some time. Well, kindly sees paragraph 4. In pursuance to the show cause notice issued by the division bench of the High Court at Karnataka, statement of objections was filed by the detaining authority. According to the appellants, the High Court did not consider the case in proper perspective and dismissed both the writ petitions. The detainee, aggrieved by the impugned judgment of the High Court, has preferred these appeals before this court on the following grounds. First is non-supply of paragraph 4, Mallam.
Count also only a preventive detention. No. They detain to prevent him from being engaged.
When did you get this order? From 5th September?
At the time when I was
Arrested.
arrested.
Yes, what do you say? You are there. You are for?
I'm for response number 3, 4, and 5. The authority sponsoring the detention for Director of Revenue Intelligence. Lordship, what has fallen from my learned senior friend is that the foundation of the entire writ petition is on 2 grounds. The grounds are that the petitioners, the detainee has been detained, but when it has been detained, the grounds of detention and the relied upon documents has not been supplied to the said detainee. With deepest humility, Lordship, I submit that is an incorrect amendments made in the writ petition. The grounds of detention and the relied upon documents are short to be served upon the detainee. The detainee has himself refused to accept it. Those things have been totally suppressed in the writ petition. I have the documents to show to your Lordship that he was detained. He was detained on 19th of September, on 20th of September. Not 9, 19th.
No, 19th.
Yes,
I've
19th.
said.
Your Lordship kindly comes
19th.
to Lordship kindly comes to paragraph 9.
No,
The
Mr.
19th.
Yes.
I have taken it down, right?
Yes.
He
Your Lordship,
submitted.
if your Lordship kindly comes to paragraph 9, it is also stated therein that he has been detained on 19th of September. On 19th of September, the detainee was detained. On 20th of September, the authorities concerned went to the correctional home to serve the documents, the grounds of detention as well as the relied upon documents. He refused to accept it. Thereafter, we made a Panchnama proceeding to serve it upon the detainee. Even then, he refused to accept it. We thereafter subsequently made another attempt on 3rd of October 2023 to serve upon him. He has refused to accept it. If your Lordship kindly peruse it.
Kindly sees the Panchnamas, whether they contain any signature by the correctional
I
home
will show to your Lordship
superintendent.
everything.
Therefore, your Lordship will kindly be satisfied on that issue. If that is so, then it is difficult for me to be. But if it only contains my signature, your Lordship will kindly consider whether the circumstances which are there.
Lordship, this is the Lordship kindly text the Panchnama and the receipt dated 3rd of October.
Well,
Where is the?
Yes, Lordship kindly.
Can we be provided a copy, my lord?
Now Lordship kindly comes to the Panchnama.
File an affidavit.
Very well, we shall file an affidavit. We shall file an affidavit. And if your Lordship kindly sees it for a minute, Lordship. If your Lordship kindly takes the Panchnama dated 29/2023. Now this is the Panchnama.
Your signature.
And Lordship kindly sees he has signed it. He has signed it.
Kindly, my lord, I don't have a copy.
He has signed it. He has said that I refuse to accept it. I have refused to receive any documents, and he has signed it.
Where
On the 3rd page, Lordship kindly sees the 3rd page of the Panchnama.
I have refused to receive any document.
As well as in the letter dated 3rd of October 2023.
So is Mr. Ganguly.
And it's a suppression of material facts.
Yes, in both he has,
I will not accept any document.
and his signature has been attested
By the correctional home superintendent.
treated.
So the entire petition does not stand you.
Well, then may I subject to what falls from your Lordship? There is always a time period. Are you ready to accept it? Huh? Well, can it be supplied to the wife of the detainee?
We can supply to the detainee himself. One more time. Once again, we can supply to the detainee himself.
Because
Suppression, then it will go against it. Better choice is to withdraw the petition.
well, my instructions now is that he was coerced to sign certain documents.
But it has been attested, Mr. Ganguly. We could have understood had there been a sole signature that
Well,
was accompanied by a
Well,
statement.
would your Lordship be kind enough
There
to
is not
see?
even a single
Act
government
second,
that he has been coerced in not accepting the functionality, not
Sir,
accepting
why
the
you have
document.
not
Well,
been arrested?
Well,
You have not been arrested.
well, would it be the pleasure of your Lordship to kindly see the so contain any counter signature by the controller?
Yes.
20th September. Refer to the
20th September, 3rd page, and 3rd October.
supply. Second.
To whom?
To petitioner. Petitioner or to detainee.
Well, in view of those facts, well, I have, it's only that since it relates to an issue of preventive detention, would it be the pleasure of your lordship to direct that it be served upon the wife of the detinue or upon the petitioner, who is the brother-in-law?
Has refused. He said, I will not take it. How can how can we relate in such circumstances? You find out the brother-in-law and
Very well, I leave it to your lordship.
Or we can again serve it upon the detainee himself. We can again serve it
Well,
upon
it
the
keeps
detainee
it, keeps
himself
it
if
on
the detainee
Tuesday.
accepts it.
Keeps it on Tuesday. Well, this matter kindly adjourns it till Tuesday. Well, in the meantime, let them serve it. We will accordingly instruct the.
Why, Mr. Ganguly, there is a suppression. Why should we enter?
Well, the person was in detention. The applicant is the brother-in-law. He may not be completely aware of all the facts in those circumstances.
That petition has been drafted on that sole ground, Mr. Ganguly.
I understand, my lord. Yes, that is true.
কি দেবো? কিচ্ছু দেবো না। ধর আগে তুমি আমার দাও, আমার লোকটা দাও। কি দেবো? আরে 5 নম্বরটা
তো ফেরত দিয়ে দিয়েছি
পঞ্চম
বোধহয়।
কোথায়? আমি নিইনি।
ফেরত দিয়ে দিয়েছি বোধহয়। 20th, 3rd এর তাই তো। এই তো উপরেরটা।
So, Mr. Ganguly, do you withdraw or do you pass?
কি করবো? Well, it kindly passes an order to that effect. Recording that the submission, because what can I cannot, because otherwise, well, if I withdraw, then I will not be able ever supplied with the copies, with the grounds or the orders. So that is why, subject to what falls from your lordship, if it could be just adjourned till Tuesday, well, in the meantime, we will accordingly legally instruct them, provide them the necessary legal instructions so that the service, because your lordship can appreciate this is an issue of preventive detention and the
client knew, he ought to have disclosed to the council concerned.
no, the client did not know it. Well,
Brother-in-law,
he did not know about it because this person was, and there is no access which is being provided also. No interview, nothing is being provided to this person.
Mr. Ganguly, there cannot be a second habeas corpus. Suppose it is given to you.
So then the matter ends, my lord. That's why then it becomes infructuous. I will withdraw, my lord. It doesn't, because that issue, whether there is delay or not, is covered by this.
Mr. Ganguly, ask your junior to take instruction and decides to withdraw. Let him withdraw or be pass on.
Very well. Very well.
Will be there at you are appearing for?
মানে ইউনিয়ন অফ ইন্ডিয়া।
You have asked your junior to have a consultation.
My lord.
That it needs to be withdrawn, it will be withdrawn. Then there will be no comment on our part. We will not go into that.
Well, the difficulties your lordship will appreciate. Well, the petitioner before your lordship is not the detinue. He is in a representative capacity. The difficulty is that whatever he has received information, he has submitted. But what has happened in the jail, in the correctional home, is not within.
Record that in our. Then we pass our. The present.
But then how do you ultimately get it?
At least the power for our second time application file.
Present petition has been.
Also to representation.
My lord.
The present petition has been prepared, primarily paying for following.
अरे भाई हम मामला को चंद्र में पेगे गए की
আচ্ছা না হলে ইয়ে ফিরে দিন এইভাবে নাকি না করে টেনশন ওনাকে চ্যালেঞ্জ করলো এবং অবশ্যই
এক্সট্রা কপি নেই আমার কাছে।
Occasion of the jurisdiction of this court under Article 226 of the Constitution of India.
মানে হেভিয়াস
The petitioner has questioned, this petition questioned question the sustainability of one detention order dated 5th September 2023 issued by the Joint Secretary to the Government of West Bengal to the Government of India, Ministry of Finance. Respondent number. It has been forced. Respondent number 5. Respondent number 2. Superintendent of the government. And the advocate appealing for the petitioner submits that the petitioner was detained and petitioner was arrested.
The brother-in-law of the petitioner.
Oh, acha.
And the arrested হচ্ছে customs act জানি না বলে এটা কোনটা বলছে কপি দেবেন না কিছু refusal habeas corpus doesn't apply. It's not going to succeed.
Detained one, detained one Sheikh Sirajul Haq, a relative of the petitioner. Mr. Ganguly Lanet advocate appearing for the petitioner submits that Sirajul was detained by virtue of an order dated or by virtue of the aforesaid order dated 5th September 2023 in exercise of the power under section 3 within bracket 1 of the Conservative of Foreign Exchange and Prevention of Smuggling Activities within bracket Copy Posa Act 1974. So, drawing our attention to subsection 3 of section 3 of the Act of 1974, he submits that the authority was required to communicate the ground of detention and the documents relied upon to the detainee. Ordinarily not later than 5 days, an exceptional case, and for and upon after recording the reason in writing, not later than 15 days from the date of detention. He submits that although the Sirajul was detained, was detained 19 September, but the ground of detention and the document relied upon had not been issued had not been supplied or provided to the petitioner. In compliance with Sirajul, in compliance with the clause 5 of Article 22 of the Constitution, which mandate which mandated the authority making such detention order to communicate the detainee the grounds on which the order was made and to afford him an earliest opportunity of making representation against the said order. He submits that since the subsection 3 of section 3 of the Copyposa Act and the clause 5 of Article 22 had not been complied with, the detention of the Sirajul is totally illegal, and hence appropriate direction should be given to produce the corpus of Sirajul, and the direction should also be given to release the Sirajul. To release the class as according to him, as according to him, he is under illegal detention. Stop. Mr. Appearing for the respondent, appearing for the respondent, vehemently oppose such contention made by Mr. Ganguly. He submits that the said Sirajul was detained. He submits that the petition has been filed, suppressing the material facts. Stopped. He contains that the detainee was detained on 19th September 2023, and on 20th September 2023, the concerned official of the respondent had been to the correctional home and to supply the grounds of detention and the documents relied upon to the detainee, but the detainee has refused to accept those documents. And in support of contention, he further submits that against the respondent made an attempt to serve those documents to the deponent on 3rd October 2023, but the detainee refused to accept those documents. Drawing now. The documents as produced by Mr. Ali is taken on by Mr. Sotas. As Mr. Ganguly submits, the petitioner is the brother-in-law of the detainee. Sirajul is the brother-in-law. Petitioner brother. There may be miscommunication in between the petitioner and the detainee. He submits that a direction may be issued upon the respondent to supply those documents to the wife of the detainee or to any other learned advocates, Peru's on record.
He wrote in English. He's writing
From the document is clear as day that it is as produced. From the documents as produced, it is clear as day that the respondent took it is clear as day that respondent took attempt to serve the grounds of detention, to serve the documents containing the grounds of detention and the documents relied upon by the respondent, to the detainee on repeated occasion, and the detainee refused to accept those documents. So it cannot be held that the respondent has acted in contravention of subsection 5 of section 3 and the clause 5 of article 22 of the Constitution of India. So there is no material to lead us to infer that the detention of the detainee is illegal, and hence there is no scope to interfere in the writ petition and to issue any writ of habeas corpus. Accordingly, the writ petition is
Only one indulgence, I would pray. Since your lordships are relying upon the documents which were handed up to your lordships, at least a copy may be supplied to us by my learned friend. No, my lord, it relates to negation of my prayer, and he's relying upon that, my lord.
We have kept it on record, so they can obtain certified copy also of this. You can just give a Xerox copy. Proceedings can be done.
The lordship directs, I cannot say no to it, but my lord, these are privileged documents, and
How?
that is the difficulty.
It contains my signature.
Because it's a preventive detention process is going on. Therefore, my lord, it's a kind of a confidential document which we cannot hand it over to them. But if your lordship directs, I have to hand it over.
We are dismissing the petition on the believing your statement. These are the documents. Mr. Ganguly obtains certified copy of the.
Kindly consider, these are photocopies.
Yes.
I certified copy, Pabo.
Why will he not give certified?
These are photocopies. Certified copies may not be provided. Otherwise, let him give it by way of an affidavit.
It has been taken on record.
Very well, I shall. If your lordship directs, I have to give. Your lordship kindly records that. Your lordship kindly records that in that case that we have handed over as per your lordship's direction.
This has nothing to do with the process. This is only my refusal.
So why you are anxious as regards this issue? Because we have disclosed the documents, we have mentioned the.
If your lordship directs, I am bound to give it.
We are wanting to know.
Very good.
You are saying it is confidential proceedings. We are wanting to know, as the formal judicial proceeding has been initiated, we are passing order on that. So this becomes documents disclosed. You are keeping it on record.
I'm handing it over. If your lordship kindly records only one line that we have handed over a copy of these documents pursuant to lordship's direction. If your lordship kindly so kind enough to record it.
We are not passing any. Don't be so.
You are giving it to Mr. Ganguly. Not to the petitioner.
Anyway, this only reflects my refusal. It's not part of that process by which detention order is passed or subsequent action. And I'm deeply obliged.
Grateful to your lordship.
Lordship, I sincerely apologize, Lordship, for I was before court number 6. I sincerely apologize.
Constitution that coffee kosa it is written to you take it back after we sign the order.
Four.
Lordship, I am appearing for state, Lordship. 4. I sincerely apologize, Lordship, but here.
Now fight the dog.
Oh, geez. Oh, that Sikkim matter.
Yes, yes, Lordship. The girl has been recovered, Lordship, and the accused also has been arrested, Lordship. This is a report, Lordship.
My lord, the girl has been recovered, my lord, and 2-3 months payment, my lord, the girl is. It is informed.
Where she is now? Which home?
Lordship, just a moment, Lordship. I've just CWC, Lordship, page number 3, Lordship. CWC, Poschim Mednipur.
Where you are reading? Page. What is the age of the girl?
Around 15 years.
15 years.
15 years.
But the father.
I am the father.
Namchi
It's a fact,
District
she's
Correction.
pregnant. It's a fact.
Yes,
she's
and
pregnant.
she is at Namchi District Correctional Home.
The accused.
No, the accused.
My lord, my only one submission, my lord, that is, my lord, informed from my client, my lord, that from the family of this, my lord, the accused person, my lord, want to abort, my lord, the issues. So, my lord, that is, my lord, this taken on record. If, my lord, he abort or not abort, that is, my lord, completely the consent of the victim girl and his family, my lord. That is not, my lord, this for this only, my lord, the wish of the accused person.
Domain of ours.
My lord,
Subsequent matter, we will not.
Ashok.
not any getting pressurized for my lord. That is that. Not,
Heart Mr. Vasula. Heart Mr.
recording.
Vasu. What is that?
No, my lord. Affidavit service kept on.
Video service final. Heart Mr. Vasula and dead to be deputy petitioner, Miss Maria Mulli, and a deputy deputy for the state service. That the victim girl has already been recovered and has been handed over to Child Welfare Committee.
Handed over Child Welfare Committee, Poschim Mednipur.
Poschim Mednipur. Where is that?
Where is the home? Where is the home?
Lordship, the name of the home is not specified.
You said just now Namchi.
And that is the correctional home where the accused is there.
And handed over to let the report, as produced, be kept on record. Stuff. Since the victim girl has already been recovered, no further order is going to be passed in the present petition, and the same is accordingly disposed of. Yes.
My lord, your lordships, kindly may I have a copy of this report, my lord? Thank you. I am grateful.
Grateful, Lord.
That is only for the advocate, not to be shared with your client.
No, my lord, my lord. I will, my lord, keep, my lord, this secrecy. Yeah.
Because that is an
my lord.
advocate's
It is, my lord. I am handed over to this, my lord, this father of the victim.
See that it does not, your client does not carry it away.
No.
Keep it with you, inspect it, advise accordingly.
My lord.
Yes.
Grateful.
My position, Lord.
Yes, your other side has come.
Not yet.
Yes, Mr.
My file, my lord, the affidavit of service, my lord.
This is a new motion.
Yes, my lord. Twice, my lord, this has appeared before your lordship and nobody turned up. Though, my lord, I've served upon them by hand. But it is a matter for subsistence allowance, my lord. So this is why, my lord, this matter is urgent and I just pressed before your lordship. Even, my lord, they are not appearing, even in spite of the service by hand. My lord,
What is the?
yes.
This is from the tribunal's order.
Yes.
What tribunal directed what?
My lord, I said that as per their rule, after 3 months of myself keeping in suspension, they will have to, my lord, increase my subsistence allowance from 50% to 75%. So, my lord, thereafter, the clause in the rule, my lord, is that if I do not cooperate with this within this period of suspension for the disciplinary proceeding, in that event, my lord, that will not be increased, that will be decreased. If I do, my lord, cooperate, in that event, my lord, it has to be, my lord, increased. So, my lord, the impugned office order, it says that I did not cooperate. And the tribunal, only by quoting that particular line that I did not cooperate, rejected my claim. I have come before this honorable.
So how can you show that you
My
cooperate?
lord, there is some admitted position. This is why, my lord, just pressing your lordship. My lord, a very short, my lord, history of this matter is that I am a track maintainer too. And in 2018, my lord, I was charge sheeted. And the charge was that I took part in a fake recruitment process. Means, my lord, I was in a racket of a fake recruitment process in the railways. So, my lord, what happens? 2018, there was a charge sheet issued.
What interim order you are wanting?
My lord, the interim order, I pray that my
50%.
I am. My lord, interim order I'm praying, my lord, I tell your lordship that it should be increased to 75%, my lord, because
That is the final belief.
it does, my lord, lordship, only just if I just can place my admitted situation right now here. But 2018,
Your final belief is give me 75%.
my lord, if they do not, my lord, appear, lordship, we can appreciate only one thing.
We will fix.
My lord, lordship, if I'm permitted, my lord, if I'm permitted, my lord, the admitted position, because they have come before this, the Union of India, come before this honorable court earlier occasion, by way of filing a WPCT against an order, which, my lord, quashed the entire proceeding. Only on the ground, the disciplinary proceeding, only on the ground that the relied upon documents were not served upon me in spite of specific direction of the learned tribunals in 3 other.
What interim order you want now?
My lord, I tell your lordship right now, if I just, my lord, permitted, my lord, to address to your lordship, the interim order,
Interim order you want?
that there is no other option than increasing my subsistence allowance to 75%.
You are
My lord, it does, my lord. Only one thing, my lord.
Final belief you are
My lord, it does. It is the final release. Yes.
Made returnable, Mr. Roy.
My lord, if because this could have been, my lord, because I would not have, my lord, pressed before this honorable court if it is not an admitted situation. And if
You have to go into that. There is no
because they, my lord, will not appear, my lord. Third occasion they did not appear.
If they don't appear, we will hear expert.
As your lordship, please.
But your tribunal application was decided upon exchange of evidence.
My lord, yes. But everything is there on record.
Now your enhancement you sought from which year?
My lord, I was after this honorable court's order, that the entire order for my dismissal was set aside by this by the learned tribunal, challenged by the Union of India, affirmed by this honorable court, and I was reinstated in this service and was put in suspension on that from that particular date, 2020. I was placed in suspension since 2020. They say that I did not cooperate for 3 months. My lord, it has been an admitted position that they have been acting stubborn and did not give us the relied upon documents. So, question of, my lord, my non-cooperation does not even arise. It is, my lord, even.
Their absence from communicate.
Evidence of service filed by the petitioner be kept on record. Stop. In spite of service, no the respondents. Stop. Mr. Rai, learned advocate appearing for the petitioner submits that that the original application was hard upon exchange of reply and rejoinder. Stop. All the pleadings and the documents upon which reliance was placed before the tribunal have already been annexed to the present petition. Stop. Thereof is the matter for final hearing. in the daily supplementary list of this court on 1st December. The petitioner is directed to communicate this order to the respondents within a week from date and to file an affidavit of service on the returnable date. Stop. It is made clear that in the event no one appears on behalf of the respondents in spite of service, this court would be constrained to proceed ex parte. Yes. Communicate করতে বলেছিল? You communicate.
You communicate.
Yes, next.
My name is Partha who is appearing for the Union of India in this matter. He engaged in court number 1, my lord. I'm praying for short passover.
What is the matter with that?
The matter is that the petitioner last 20 years worked as a casual worker in the under postal department, but the tribunal reject my application only on the verbal detachment. On that ground, the tribunal rejected my application. I pointed out the order, page 92. On that basis, your lordship directed
Yes. That what follow-up steps are
whether he can accommodate at present, lord. And on that basis, they have to take instruction, lord. Because it is
what instruction has come?
My lord, I'm not aware of the instruction, my lord.
The presence of Mr. Ghosh required.
yes. At the time of final decision, the Rani tribunal did not at all consider that.
You tell Mr. Ghosh, if on the next day he does not get it, we call the officer. We will direct personal
Lordship,
appearance of your
I'm praying for short passover, my lord. If
short passover. How long she will sit? When your senior will come?
my lord, 10 minutes, my lord.
My lord, one difficulty at 1 p.m. Lord, a special matter before the Chief Justice, Lord.
Next Friday. Next Thursday.
Next Thursday.
Tell Mr. Ghosh, you inform him. You inform him that whether he has got that instruction or not.
Next Thursday.
Yes, next.
I am appealing for the petition of lordship. I am praying for not today. For not today to the lord.
Next Thursday. Yes.
For 11, I appear for the appellant.
I appear on behalf of the state.
Where is the husband's?
I am for the respondent number 8, my lord. My senior is led by Mr. Fidosham. He is on his legs.
Pardon?
I am led by Mr. Fidosham. He is on his legs.
Ask him to come.
Yes, my
We have
lord.
heard it on the last occasion also, he did not come.
My lord.
It's a very short issue where
Where is Mr. Shah?
He is coming, my lord. From courtroom number 18, my lord. He is coming.
All right.
courtroom number 18 minute my matter is going on. ও তো নেই ওর মামলায়।
না 2 নম্বর কল হচ্ছে।
2 নম্বর নয় 3 নম্বর কল হচ্ছে 3 নম্বর মামলা চলছে আমারটাই চলছে।
To send information, court wants his presence.
My lord.
মানে my matter is going on in before Justice Vishwajit Basu.
What can we do, Mr. Bhattacharya? Matter was upgraded. Try to understand.
Yes.
We heard it on that date. It has to be in his presence. We can assist you so that the person can come. Passover. You call your senior.
Yes, ma'am.
Please wait for some time. Yes, next.
Beg to appear on behalf of the appellant. This was the matter in connection to that 12th regional level.
Service matter.
Yes, ma'am. There was a direction upon them to produce the panel. No communication from their side. Lordship also requested them to have a sit prior to this hearing in connection with the panel.
Mr. COVID, we cannot fix it on the next 2 weeks.
No,
My
sure.
brother won't be here.
Yes,
It's a
yes.
Third matter. No?
This is an assigned. This is an assignment.
It was assigned.
Yes.
Can you send information to Kamal Kiran or somebody whether they are with the records or not, whether they can conclude it today?
I will come back with you, Your Lordship. Let's sometime.
Pass over.
Yes.
Pass over the talk. Yes,
Yes, my lord.
you had appeared in his matter.
Yes.
No, you had appearing in his matter in court number, he alleges. Your junior said that you are busy in court number 70.
No, 18. Before just Bishwajit Basu.
But it was his matter in which you are appearing.
No, that is Kumar Roy matter.
না না এখন 3 চলছে তো
এখন
বলছে
তিন
ওটা
চলছে,
আমার
তিন
ম্যাটার আমাদের 2 ছিল সেটাই বলে
No. Our matter was 2.
Yes,
Our matter is item number 2. My matter.
yes, Mr. Shamim
Yes, ma'am.
says that my writ petition has been said to be not maintainable. He says
Oh, this
that
matter.
my writ petition has been held to be not maintainable,
Yes,
and
ma'am.
I have been asked to go to the trial. But at the same time, court has said that the dispute is civil in nature. If that remains, I will not get any relief from the trial. This is his argument. So we can,
My lord, what happened, my lord, this is as per my understanding.
Page
is
59 is the order, minute.
Order
The
in
dispute is private in nature.
Private.
Private in nature.
Obviously, there is no doubt about it.
The minute my allegation is something else. My allegation is that minute he got the
Private dispute.
our PLE.
My lord,
no. Minute my allegation was that minute there was no police verification and minute the private respondent being my husband, he got the next job without the police verification.
For your matrimonial recordings,
yes,
state has to suffer.
No. But my case is something
that's
else.
exactly.
But I have come here for deletion of only one line. But it may not be held to be a private dispute. I have alleged.
Exactly what we have told Mr. Sami. Don't open your mouth too wide, otherwise everything will go.
My lord, before that, all the
Shall modify it only to the extent that that observation stands excluded.
I think, my lord, that is not needed. Why I say so, my lord?
Not needed.
Yes, my lord. I think why, because if I open my mouth, my lord, I don't want to. Actually, my lord, what this appellant is a school teacher, and she is that school teacher whose name featured in OMR manipulation list. She married with no doubt about it. I just handed over one.
So, Mr. Sami, we are not going into details. We are not stopping you also from arguing before the tribunal that the tribunal application will also not be maintainable since it is a private.
I am exactly on that point.
That we are keeping it free.
My lord, kindly not delete that portion, because why I say so, that this is between findings, my lord. This is obviously it's a private in nature. Dispute is private in nature. That's why the appellant want to resort this dispute, and that is not a dispute at all, because the private respondent, my client, was in service from the year 2018. Initially, he entered in the service as a WBCS Group D officer. Thereafter, he selected as a Group C officer. Thereafter, he selected as a Group C officer. My lord is
First, in the from the year 2018, the private respondent was Group D officer. Thereafter, why I say so, my lord? Because why I say so? Because of that, my lord, if any dereliction of service, my service as a public servant, my lord, there is an employer. Employer might take action. But what authority the appellant have?
Exactly.
My
That
lord,
will be your argument before the tribunal if he goes.
yes, my lord. But why this portion, deletion of this portion is not needed? Why I say so? Because why she came to the court? There is a dispute between the parties, that dispute private in nature. That's why deletion is not needed, as per my humble understanding, my lord, subject to correction, my lord. Why she comes to the court? Because there is a dispute between the parties. I want to demonstrate that why she came to the court. After marriage with me, she entered in another relation. Not only that, she made a complaint against that person also. And one PS case number, Masdroni PS case number 217 of 2022, that is lost. And what's the complaint? Giving assurance of marriage, the second person, after marriage with me, extramarital affair with the second person. And thereafter, this appellant demanded 32 lakhs from me. I'm not agreed to. Thereafter, she resorted this court. So that's why, my lord, I says this is a private dispute. She wants to use this court as a tools. So that's why this dispute is private in nature, my lord. There is no relation with my service, with my public employment. If anything, dereliction of service, there is employer might take action against me. I was in service from the year 2018. Thereafter, I got another service. Initially, I was appointed as a Group D officer. Thereafter, I appointed as a Group C officer. From PVR, from that service continues. And I made several complaints. I never suppressed any fact. If I want to, my lord, what communication between me and my department, it is evident. I was in custody also. And I made this particular prayer. Kindly see the what letter I wrote to the department regarding PVR. I mean, detention of publication. Kindly see, the one letter I just.
Mr. Humming, we are not on that.
So that's why.
Today, you have not preferred any appeal against this order?
No, because.
You have not preferred any appeal. You are satisfied that even if there is an issue, it has to go to the tribunal, not the High Court. You are satisfied with that. But if the court has allowed that, then that remedy will be excluded if this observation remains that it is a private dispute. And moreover, court arrives at that finding without going into the merits of the matter. Court was clear that I have not gone into the merits. You go and do whatever you like before the tribunal. But there was an observation also that it is private. If that remains, then the tribunal application becomes infructuous and the court's order becomes a nullity.
Subject to correction is a humble understanding of me. Why I have not preferred an appeal? Because there is a two portion of order. One is that this is a private dispute between the parties. And another thing is that if any because it's a service dispute. If anything, any parties, might be the state, being the employer, go to the tribunal.
We have got your point. Actually, court held that it lacks jurisdiction to enter into the meeting.
As well as court held.
Since the matter is a service-related matter,
yes, no doubt.
State government employee, so go to the forum, administrative tribunal. That apart, court opined that is a private dispute.
Yes,
okay. Anytime it may be said that the tribunal application is not maintainable.
No,
Since there is a
no,
private dispute.
no, my lord. My lord, that is not my.
Facing on writ application, in the court hold that there is a private dispute or in a disputed question of facts and answer, then the court will not entertain.
My lord, with deepest of respect, my lord.
So when a court is holding that I am lacking jurisdiction to enter into the merit, so why I shall make observation?
My lord, with deepest of respect, my lord, in the writ proceedings, there are several parties. One is that, my lord, the present appellant, as well as the state, being the employer. Any party can went to the court. Any parties. So second part regarding before the tribunal, the adjudication before the tribunal, applicable for any parties. The first portion, that specific portion, page number 59. This dispute between these two parties are private in nature, no doubt about it. So if deletion, my lord, I think, my lord, that's the adjudication of writ proceedings was that before the single judge, that between these two parties, dispute is private in nature. If anything, the delegation of service or any service dispute may be arose by the competent parties.
Exactly.
So, my lord,
So you are saying we are not disagreeing with you. You are right that the dispute is between husband and wife.
yes, my lord.
That cannot be anything but a private dispute. We are not disputing that.
Then, my lord, kindly not delete.
But if that observation remains, then the tribunal application becomes a nullity. He cannot file any application before the tribunal and get an order. Then the High Court direction will become a nullity. Right? We are not commenting on what you are saying. You understand that you are absolutely right. This is the bickering between the husband and the wife. You are being falsely entangled. We understand that. We understand that. That is private in nature. There is no dispute.
Then
when the High Court has said that it is also relating to the recruitment procedure, go to the tribunal. In tribunal will not adjudicate that also. Tribunal will say private dispute, dismiss the application. Then the High Court observation becomes a nullity. Present appeal has been preferred against an order dated 17th of August 2023, passed in a writ petition being WPA 18207 of 2020. Mr. Bhattacharjee, learned advocate, appearing for the appellant submits that the learned single judge, without going into the merits of the matter, arrived at a finding that I observed that the writ petition is not maintainable since the dispute is private in nature. If, according to him, if this observation remains, then the appellant will be debarred from filing any application before the state administrative tribunal. So there is also a direction in the impugned order that the petitioner that the writ petition is not maintainable since the petitioner was seeking to challenge the recruitment procedure of a state government employee. Stop. The contradiction stop. Mr. Shamim Ahmed, sorry. Shamim learned advocate appearing for the private respondent submits.
8.
Private respondent number 8 submits that there is no infirmity in the order including the present appeal. The writ petition was in fact filed in view of a dispute between the appellant and the respondent number 8, who happens to be the married couple.
Yes.
Mr.
Muhammad Idris.
Mr. Idris, learned advocate, enters appearance on behalf of the state respondents. We have heard the learned advocates appearing for the respective parties and considered the materials on record. From the order impugned, it appears that the court did not go into the merits of the petition. However, the writ petition was held to be not maintainable on two grounds. Stop. On two grounds, dash. Since the dispute according to the court was private in nature, and since the petitioner since the appellant was challenging the recruitment procedure, comma, ought to have approached the learned tribunal. Stop. In our opinion, upon having held the writ petition to be not maintainable before the High Court, as the dispute was as the challenge was pertaining to a recruitment procedure, the learned procedure of a state government employee, the learned single judge ought not to have observed that the dispute between the parties was private in nature, and that too without going into the merits of the case. Stop. In view thereof, the order dated such and such, order dated
17 August
17th August 2023 is modified, and the said order shall be read, excluding the observation that the dispute between the parties is private.
My lord, one thing is that, my lord,
Dispute between the appellant and the respondent number A is private.
my lord, that doesn't mean, my lord, kindly give a rider. Otherwise, my lord, if I take that point before the tribunal will not entertain that point, my lord. That doesn't mean kindly give a rider. That doesn't mean I can't take this point before the tribunal. My lord, kindly give this rider. Otherwise, tribunal will not entertain my point, my lord. Because this is a deletion by the division bench, my lord. They will, because
That is what we said.
my lord, kindly give a rider. Otherwise, my lord, we face this problem, my lord, because my lord, kindly give this rider. My lord, otherwise, my lord, kindly.
What Mr. Salim is saying,
my
that is always open to the court.
My lord, kindly give this rider, my lord, because they will.
Without saying, Mr. Salim,
My lord,
It's always there.
we face this.
unnecessary.
My lord, we face this problem. Otherwise, my lord, kindly, my lord, appreciate, because they before.
Tribunal.
No.
We have said that liberty has been given to approach the tribunal. In that occasion, this observation ought not to have been made. We have not said that it is not a private.
My lord, kindly give some clarification. Otherwise, my lord, we face this problem because they take this point because this point is deletion by the.
Our order contradicted.
My lord, nothing is admissible. Kindly give this aspect. If it will be kind enough. Otherwise, my lord, they interpret this.
Explain, you can
Yes, my
certainly argue that. There is no dispute. Yes, next.
Grateful, my lord.
Yes, where is Dr.
11. Item number.
Dr. Patria, got it.
My lord, I could not get the complete instruction, and I also could not prepare the affidavit. The time which was given to me was very short because the bench will not be available. Yes, an exception to their supplementary affidavit, and also the records which we would have included in that affidavit.
Then it has to go beyond the vacation.
Kindly keep it immediately after the reopening. We can also utilize the vacation to get everything ready, and it is assigned, so we cannot run away.
Order shifted out each year. Dr. Patro learned advocate appearing for the commission based for extension of time to file the exception to the supplementary. such is considered and allowed. Stop, let such exception be filed within 2 weeks from date. A copy to Mr. Gobi Learned
Very well. Yes.
Appellant. This the matter for further consideration in the daily supplementary list of this court on 20th November. It is an assigned matter.
Yes, yes. 20th.
Dr. Patro, finish it off.
Yes, yes.
Long page.
Only one day it will be required. Only one day. If I can come with the proper instruction, only one day will be required.
Yes, call that matter where is that? Yes. Your other side has come. Yes. Where is Mr. Bisa? Yes, কত নম্বর item?
13.
30.
Yes,
Oh,
130.
30 Yes.
My lord, Lordship was kind enough to allow us to take exception against the report of the Kolkata Municipal Corporation.
We are trying to have your presence, Mr. Chakraborty.
Lordship.
You were not there earlier.
Yes, my lord, on the first occasion I'm here, my lord. Yesterday not.
না না বলছি একদম প্রথমের দিকে আপনি মাথায় ছিলেন সেটা বলেছেন
Yes.
So this is, my lord, the exception we have taken. We have circulated our this copy. My lord, what happened? My lord, permission which they are claiming, my lord, they have taken under Rule 3E. My lord, Rule 3 means, my lord, the building rules. In case of repair, mainly, my lord, the roof repair, this particular provision is being used for the purpose of taking permission from the Kolkata Municipal Corporation.
So they wanted permission under 3E.
E.
That is for repair.
That is for repair. I am showing, my lord.
No, no, all right. Tell us the story.
Yes, sir. And on the basis of that particular sanction, they are doing certain construction which they cannot. For that, my lord, regular sanction is required to be taken from the Kolkata Municipal Corporation. And only in certain cases, permission need not be taken. If someone intends to do whitewashing, change of partition wall, and my lord, some trivial work, if required to be done, my lord, one can come within the four corner and ambit of Rule 3 of the Building Rules 1990. My lord, 2009. Building Rule 2009. Only one provision is there. In the event of damaged roof, my lord, they can do that. Permission full-fledged not needed. My lord, permission in terms of the Rule 3(2)E is, my lord, granted. In the instant case, it was granted. Then I can show the photograph. Lordship will see. They are, my lord, doing pillars, shuttering works. They are trying to make two other separate room and all these things, which they cannot. And my lord, there is no back space, front space, rear space in terms of the building rule. One cannot get permission under the regular provisions of the Kolkata Municipal Corporation. My lord, sanction cannot be allowed in any manner whatsoever. I am showing, my lord, the photograph. Lordship will find.
First come to the order of the writ court.
Lordship.
What is the writ court order? This is an appeal against an interim ad interim order.
Yes, sir.
First in a suit.
Shoot.
Kindly come to the writ court.
I am coming.
Where is that?
My lord, I am coming. That is in the supplementary affidavit.
Page 5 of the supplementary.
Yes.
Page 5 bottom, my lord.
Supplementary affidavit গুলো
Here are two supplementary evidence. Two supplementary.
only one. একটাই তো সাপ্লিমেন্ট দুটো ওগুলো ডিএস টু সাপ্লিমেন্ট কেন দুটো কেন
Bottom, lordship, paragraph 4. The executive engineer of the concerned borough is directed to cause a spot inspection upon prior notice to all the necessary parties and prepare a D sketch and forward the same to the petitioner so that steps can be taken. My lord, turn to next page, my lord, to demolish the unauthorized construction by the petitioner. Then, my lord, let the spot inspection be conducted at the earliest, but positively on 12th May 2023. The D sketch shall be forwarded to the petitioner immediately thereafter, but positively by 17th May 2023. The petitioner shall take steps for demolition of the unauthorized construction by 4 weeks thereafter. After effecting the necessary demolition, the petitioner shall intimate the same to the corporation. Executive engineer of the corporation shall re-inspect the premises to ascertain as to whether the demolition has been made in accordance with the D sketch. In accordance with the D sketch, the executive engineer of the corporation shall thereafter take a decision whether to permit the petitioner to continue with the construction work or not. The said decision shall be communicated to the petitioner. The writ petition stand disposed of, the report filed by the engineer of the corporation, so and so. So, my lord, the last occasion, my lord, the report was before this honorable court.
No, kindly come to the next page.
Next page.
8th of May 2023.
Yes, my lord. This is a notice under section 400 subsection 1. 400 subsection 1 means, my lord, it is to be placed before the municipal commissioner or its delegate for taking appropriate action. Before that 401 and 400 subsection 1 means, my lord, it is to be placed before the municipal commissioner for taking appropriate action. And, my lord, yes, my lord, that on inspection it has come to the notice of this department that a construction is being carried on or has been raised at the premises number so and so, 115 NS Road, ward number 42, Borough 5, Calcutta 1, in contravention of the section of 400 subsection 1 of the KMC Act. That the said construction prima facie is beyond the approved sanction plan.
Right.
Sanction permit.
Then you are directed to appear before executive engineer on 11th May.
Lordship.
In support of your consent.
Lordship.
Page 8. What happens?
My lord, page 8, my lord, it's a demolition sketch. Demolition case number so and so. And, my lord, unauthorized work, lordship will find, my lord, paragraph 3, deviation from the BS plan, wide serial number so and so, dated 13/12/2021. When detected, my lord, detected on the
paragraph 3 of what you are reading?
My lord, page 8 I am reading, my lord. My lord, first, my lord, it is written the premises number 115 NS Road. Then owner person responsible, Ramendra.
From such a
Yes. And these are the deviation, infringement of the Kolkata Municipal Corporation.
That was intimated.
Intimated.
Now next page.
And here, my lord, prior to, my lord, leaving this particular.
Lordship. 18th April was the order of the writ court.
Lordship.
8th of May notice was given to them, come and meet with us.
Lordship.
Because you are raising illegal construction. Then they conducted an inspection and they found that the deviation is such and such. So they prepared a demolition sketch.
Page 10, my lord, demolition sketch.
Now page 9.
Page 9 is, my lord, demolition sketch. My lord, this is order of the demolition sketch matter, white number so and so.
So demolition sketch
Page
is
9, focus notice.
page 9 is
It's focus notice, my lord. I may excuse, my lord. And page 10 is, my lord, the demolition sketch. Lord.
It was issued. No, order of demolition.
প্রথমে focus notice এর connection এটা করছে।
না, এটা হচ্ছে order of the GKS.
Whereas on the constituency focus in this construction is commenced carrying deviation of sanction plan as ever ordered itself to stop construction. Order of demolition of the said construction. এবার demolitionটা হচ্ছে
deviation আছে সেগুলো কর্পোরেশন অর্থাৎ রিজন করবে এইটার আগে জায়গায়
Yes, so one more important feature, Lordship will find from page 8, 9, 10, 11, everywhere, my lord, notice has been issued in the name of present appellant. We have made complaint. They did not feel it necessary to send us a copy. My lord, never, my lord, that being the situation. And my lord, kindly come to page 11 also. Page 11, my lord. It's a written law, it's a letter addressed to the executive engineer. And my lord, they have admitted they have done some demolition work. And my lord, sir, as per the order of demolition, we comply the said order. Photocopy attached herewith. Please inspect the same and take necessary action. Please issue the notice 401 withdrawn. Later and oblige. My lord, our submission before this honorable court, my lord, this is not the way to withdraw notice under section 401. It is to be placed by the before the municipal commissioner or its delegate in presence of all the side matter will be taken up for hearing. In the event, my lord, the special officer building is satisfied.
Then why didn't you prefer appeal against Justice Sinha's order?
No, my lord, that this is
Chakraborty, do not elongate the issue.
Lordship,
This is the third time we are hearing.
Lordship, kindly see me.
Your junior, we put a specific question.
Lordship.
Were you present there or not there?
Lordship.
First day, adjournment taken.
Lordship.
Second day, he was sick. Third day, you are coming and arguing.
Lordship.
Please do not reopen the Pandora's box. We are on the short issue. That were you present at the time of inspection or it was done in your absence? Now your junior told us, first day he told us we were not present. Next day it so happened that there was a dispute as to whether person was present or not. We told him, all right, we are adjourning, please assign. So today we are only to see whether you are there or not.
Yes,
finished.
And
Now we told Mr. Vishas that you produce the notice, that you gave it to the private person. He produced the notice.
Lordship. And my lord, Lordship allowed us to file exception. We want to make this submission, my lord, under Rule 32E.
No,
this cannot be done.
No, but that is not our concern.
Lordship.
We have to see whether writ court order has been followed.
Lordship.
In that case, we cannot prevent him from raising construction.
No, my lord,
If he raises,
Lordship.
that gives rise to a fresh cause of action, Mr. Chakraborty. We are having jurisdiction as to whether grant of ad interim order was right or wrong.
Our humble submission absolutely right because of, my lord, what they are doing. If this honorable court kindly see, my lord, this
exception, what is
I'm showing, my lord. Kindly come to, my lord.
That thing is not coming, whether you are present or not at the time of inspection.
They have not issued any
তুমি গেছিলে তো একদিন যখনই ও গেছিলে তো একবার এটা বলে দাও জজ সাহেবকে সেটাতে নাম
court order দিল
Lord, kindly see page 18.
on 8 আমাদের যখন হ্যাঁ
এইখানে নোটিশ অল নেসেসারি
জানি
রিসেন্টলি হয়েছে
এই নোটিশ
এই যে রিপোর্টটা দিয়ে কোনটা দিতে
এই রিপোর্টটা দিয়ে কেসটা হচ্ছে এইটা একটা ডিমিনেশন কেসও ইয়ে করেছে সেই ইন্সপেকশনটাই এ ছিল কি ছিল
page 18 Lordship will find well on the last.
Mr. Chakraborty, come to the order of the writ court.
Lordship.
What paragraph which you placed just now?
My lord, page 5 of the supplementary evidence.
Come, let us read together.
Lordship.
Page 5. I don't know how your junior has briefed you.
Lordship.
Our query was this.
Lordship.
What was the first direction? Executive engineer is directed to cause a spot inspection upon notice to all the necessary and prepare a sketch. This sketch has been prepared. They have demolished that portion. They went for re-inspection, found demolished. That was the compliance letter part. We wanted to know from your client that was any spot inspection held prior to the sketch, and if you were present there.
No. At that point of time,
from
no.
your exception, where you have stated that?
that such inspection was not done
Not done.
in your presence.
Lordship.
Show us one line in your exception.
Page 7, my lord.
Page 7
Page 7
of
exception. 19. And this is contrary to, my lord, page 18, the document annexed in page 18.
page 18 of the exception.
This is the notice. This is absolutely, my lord, subject to correction of false.
Page 18 is a photograph, Mr.
Photograph.
No, no.
It's page 7 of the exception, paragraph 19 is the statement.
Yes.
Point inspection.
Statement and contrary document is page 18.
18.
18, 1-8.
Joint site did not আগেরটা কবে করেছিল না ওটার পরে আগেরটা কবে করেছিল
And in my report, my lord,
requested এটা whose signature is this? Dev Kumar De
yes,
গ্রহণ করলাম. Now after on 8th you held the inspection and prepared the D-sketch map.
this sketch map, my lord, was prepared prior to that, my lord, it was already there.
Achha.
My lord, we have executed that.
Oh, you found
During
you found that
during
that
this
is the
proceeding,
case.
already this sketch map was, my lord, prepared. We just executed. And your lordship kindly sees our report, my lord, in the second page that they were present there. Their presence was also recorded. They put their signature. Report, my lord, I've given. One more copy of the report, my lord, may I give, my lord?
No, you have given it to us.
Yes, on the last occasion I've given. This is the notice and the second page is, my lord, their attendance. Your lordship kindly sees the report. I've handed over just now. Second page is the notice and third page is their attendance in compliance with the order passed by my lord Justice Amrita Sinha.
What is their name? Mr. Chakraborty.
মানে দেব কুমার
Dev Kumar.
Dev Kumar Dev.
So Dev Kumar De was present.
Dev Kumar De is the Milord plaintiff number 1.
কত কথায় আছে দেব কুমার দে আছে হাজির আছে এটা দেখো
কোন রিপোর্ট না লেখায় না বুঝিয়া স্বাক্ষর করিলাম. So this is their attendance.
Now after that they demolished that portion and you issued a certificate that now it has been done. Yes, Mr. Chakraborty.
My lord, kindly see the order passed by the Honorable Read Court on 18/4/2023. My lord, page 5 of the supplementary. Yes. Then, my lord, kindly see on page 7. My lord, this show cause notice was issued. My lord, page 7
Page
of the supplementary affidavit. Of the supplementary affidavit. Yes, my lord. Kindly see the date 8/5/2023.
Mr. Chakraborty,
Lordship.
please tell us you were present.
My lord,
We are tired of asking these questions.
my lord, we were present, my lord, not at the very beginning, my lord. On 5/9/2023, page 18 of our exception, we were present. Prior to that, my lord, the order passed by the Honorable Read Court on 18/4/2023, after 5 months, whole proceedings was going on. My lord, every notice has been issued and all these things, hearing, withdrawal, even, my lord, kindly see the letter issued by them, my lord, page 11, that kindly withdraw the 401 notice. We have demolished it.
It may be stated that the prior notice or notice prior to demolition
Yes, my lord.
has not been given.
Yes, my
But
lord.
notice after demolition.
My lord,
was given.
demolition was not taken place in appropriate manner.
And on the joint inspection held after demolition. it was
Lordship.
present.
Yes, my lord.
Then where.
That
he
is
has
why,
stated that I have objections, such and such, such and such.
that is why in our exception, we are very,
Till that date, have you made any application to any authority that this has not been?
so we have taken exception, my lord, including all the photographs we have enclosed, showing that particular construction is going on, that cannot be done in terms of the rule 32E. And at the same time, pillars are there. They have demolished 2-3 pillars. Remaining pillars are there. Encroach, my lord, the passage and all these things, my lord. If this honorable court kindly permit me to show the photograph, I can show that, my lord. So, my lord, unauthorized construction and lordship. Kindly come to my lord. Kindly come to my lord, my exception. Kindly come to my exception, page 13. Page 12, my lord, page 12. Lordship will find, my lord. ওদের বাড়িটা যেটা হচ্ছে 115
ইউনিটটা কালাম শুধু আদা থেকে নোটিশ দিয়েছে না ডেমোলিশন কেসে 8-5 থেকে 8-9 এর মধ্যে ভেঙেছে কোন 100 8-5 এর
Malad, at 2 p.m. Malad, I have another engagement in Malad.
He will pass our order.
No.
You ask your junior to be here with the record.
My lord, we want to make one submission, my lord.
He will hear you. Any submission? Please tell us. Mr. Vishwas, if your matter ends, please try to come and be here. Okay. Where is missing?
Chakraborty will come. Chakraborty will come.
We go to 8% of employee. Related to process of notice to declare agent stuff.
সাথে গিয়ে বলে এসো বলতে আসলে বসে গেছি সাথে আছে কি বলে দেখ
ডিটেকশনটা প্রপার কতটা সেটাই যদি না
চিন্তা করছে পরবর্তী ক্ষেত্রে
না যদি ডেমোলিশনের যে পোর্শনটা ব্যাড পোর্শন সেটা তো ডিমার্কেটেড হয়েছিল সেটা রেসপন্ডেন্টের ক্ষেত্রে ভুল করেছে ওইটার অপোজিশন ও তো জয়েন্ট ইন্সপেকশনে গেল যখন
আপনি সমস্ত ইয়ে সেখানে ঢুকে তারপরে যদি অ্যাপয়েন্ট করেন সেই যাবে ইন্সপেকশন এসে রিপোর্ট দেবে আবার
পাস করেছে কার ক্লাসে করতে সেখানে করেছে কার
নাইনে আসে নাইনে সেভেনও করতে পারে
দিয়ে আমার
যদি আপনি
ইন্সপেকশনটা করে আপনার কি তো ডেমোলিশন
ডিভাইসটা দেখছি ট্রাক করেছে
Lordship, yes, kindly see, my lord, the supplementary affidavit. My lord, here, my lord, they have made a declaration before the municipal authority. They intend, let there be, my lord, the withdrawal of 401 notice, that is page 11. My lord, dated 24 May 2023. And my lord, subsequently, though there is no such power of the municipal authority to withdraw 401 notice in this fashion, my lord, 401 is not a, my lord, the complete action cannot be taken under section 401. It is a preparatory action to be taken under 401 stop work. And subsequently under section 400 subsection 1, it is to be placed before the municipal authority for conclusion.
But Mr. Chakraborty, how can you go into that point?
No, only one thing, my lordship, can.
Because the whatever has been annexed in the supplementary review and the exception are documents subsequent to order of justice of the writ court.
And at the same time, my lord, this particular inquiry.
If your contention is right,
Lordship,
that contention, Mr. Chakraborty, how can we decide at this?
No, lordship was kind enough on the last occasion to allow us to come back with the exception report. We have brought it to show, my lord, there is no demolition. If demolition is taken place by the person responsible, that is symbolic in nature. And photograph will show, and this particular inspection was taken place in our presence only on 5/9/2023. After the withdrawal, after the order passed by the special officer building, everything. And this is, my lord, lordship was kind enough, my lord, to allow us to submit our, my lord, the exception. We may be allowed to place our exception, my lord.
Mr. Mukherjee, Justice Sinhar's order was that hold a spot inspection and prepare the demolition. Now, this spot inspection was not held. You are saying that demolition sketch was previously existing. So, when there has been then there has been no strict compliance of this paragraph.
But even then, but as on today, my learned friend has, but after the order passed by Justice Sinha, if my learned friend alleges the violation of Justice Sinha's order,
He has not taken any step till date. Till date with regard to the arriving of finding with regard to the demolition sketch map that has been done by the corporation, handed over to him by way of supplementary affidavit. Till date, that demolition sketch plan, they have not challenged.
No, not required, because when the initial action was bad.
No, my lord, there is no question. Kindly visualize the situation. He is a tenant of a neighborhood.
Satisfy this paragraph 4 of the order.
He is a neighbor of a different holding. His case is that without leaving space, I am making some construction. Corporation goes there, found what is the illegal construction. On that basis, a stop construction notice was given. I came up before this honorable court. This honorable court directed something to be done. Initially, their action is that no, I was not present, but they were put on notice. In their presence, the again corporation visited and found whatever the illegal construction of pillars that has been constructed in deviation of the sanction plan, that has been removed. So
How
as
many
on
pillars are there?
3 pillars. Kindly looks at the demolition sketch. My learned friends, client do not want my premises to be repaired after sanction plan. I, being a person, my lord, who has put on notice that your building is dangerous, you kindly remove the dangerous portion and obtain necessary permission to make construction. I applied, obtained sanction. I was about to carry out my construction. My fault was that, yes, in deviation, I erected 3 pillars. That 3 pillars was found there, detected, demolition sketch plan prepared. I have removed that. After removal, my learned friend was also put on notice. Spot visit was made. He has also signed over there, found that yes, that 3 pillar is now being removed. Today,
Where do we find that the 3 pillars are now being?
now, Milord, this 1-page report was being filed before your lordship's court after this spot inspection, that is dated 9th of September 2023. Not a single page, Milord, that was handed over by the learned advocate representing the Kolkata Municipal Corporation.
5th of September.
Not 9th of September.
8th of September.
No, Milord, just 8th of September. Milord, the report is 9th of September. Report dated 9th of September. At the bottom, Milord.
You are reading this?
No, Milord. This page, Milord. This was handed over on the last occasion.
You
They have filed exception to this, Milord. They have filed exception to this report.
Have they annexed it in their copy?
No. This Milord report is being prepared after the spot inspection in their presence. There is no dispute on that. Kindly read on, Milord, what is the language used in the report. So at least this
First inspection was on. No. 8th September was the joint inspection.
yes.
After that, no further inspection.
No. 8th September, undoubtedly, Milord, the joint inspection held in their presence. They put on notice. They have signed the minutes. And in the report, the corporation again found, yes, whatever the construction that was made in deviation of the sanction, that 3 pillar, that has been removed by my client.
Kindly come to page 10 of your supplementary evidence.
Yes, Milord.
These are the first
Milord,
2, 3, 4 pillars are at the back.
At the back, that was as per the
Protection for conducting fresh construction. This is a 1-storied building.
Yes, Milord, yes, the existing 1-story building.
So
Dilapidated.
you want to raise construction?
No. Yes. By erecting pillar, Milord, I want to, Milord, recast the roof. That's why the question of sanction. Otherwise, my lord, my learned friend knows, my lord,
That's the roof of the existing structure.
ground floor, yes.
And no further construction.
That was the submission of sanction plan that was being sanctioned.
Do you have that sanction plan?
আচ্ছা, আপনার কাছে?
That is only for recasting the roof.
And that is the provision, my lord, under the rule 3. Damaged roof to be, my lord, changed. My lord, they have made, my lord, the room has been, my lord, constructed over the common space. I will show, my lord, from my exception.
My learned friend first.
Not say
Lordship.
making construction is a right attached to the property.
Lordship. So
I have a right to make
for that, the
construction
permission of from the
as per the prevailing building rules on my own land.
for that, my lord, the
Can-
permission is required to be
You
taken.
approach the court, civil court, claiming that your common passage
Yes,
has been
that is
encroached.
still, my lord.
Not even a
Now,
single.
question is that after demolition of 3 columns,
Still,
whether there is still common encroachment or
still,
not.
I'll show, my lord.
My lord, that my learned friend wants to show not even a single, my lord, scrap of paper showing that he has a community of interest of that passage. That is an exclusive passage of my client. Let my learned friend show a single document showing that it is a common passage attached to his holding. His holding is 117.
17,
Yes. So he
You
is
are
asking
holding 115.
15.
15.
So, my lord, he is asking my private passage to be his common passage and asking that he is claiming encroachment of that common passage, and being a tenant of a neighbor holding, he is seeking for injunction. Since it's a property, my lord, situated at Bada Bazaar.
Now, Chakraborty has also made a claim that you have no drainage system, nothing. All your waste and water you drain through premises number 117.
That is, my lord, that is the subject matter of the suit. Kindly once looks at the plan, my lord, your lordship
I-
knows
I-
for removal of encroachment, if someone is there, he has to specify 3 schedules. First, his premises, second, my premises, and the third is the encroached portion of that. Kindly once looks at the plan. I have annexed, my lord, my application for stay.
Only schedule of the.
Only schedule, my lord. Kindly looks at, my lord, page 30 of my
Yes.
can 1 of 2023.
What is plain and
Very interestingly, my lord, it's a clever drafting. Why I say many a portion, my lord, asking for encroachment even in the exception to the report, but not even a single iota of averment. What is the encroached portion? Plain, my lord, starts at
have the annexed one map. Schedule A is
Schedule A is
premises
115.
number 115.
Yes,
Schedule B is the common passage.
my lord.
4 feet 11 inch. It's a common passage. Such and such to 3 inch on the southern side, running north to south. In between, premises number 11 such and such.
So, my lord, his premises is not seen the light of the day in the schedule. What is my encroached portion alleged as has been claimed, because mandatory injunction is being asked for in the suit, but no area has been delineated that has been alleged to have encroached by my client over the alleged common passage claimed by him. It's an allegation, my lord, on air. Simpliciter, my lord, he doesn't permit me to carry on my repairing work.
Page 45 map.
Yes.
On the north, premises number 115.
Yes, my lord.
Now, the premises of the plaintiff is 117.
7.
Now, what it is the common passage. Left hand side, west, or the open passage lying in the middle, which is being enclosed as alleged.
My lord, but there is no, my lord, sketch map
That
even.
means that, yes, 6 feet by 11 inch. That means
That
this
they have
open passage.
that they have stated open
below
passage.
ground floor, back side, tin shed. That open passage claimed to have been
Common. Here it is written
claimed to
open.
have been common and enclosed by
Yes,
you.
yes. But not even a sketch map, your lordship will find, my lord, anything that has been shown to be encroached by my client. Corporation is an independent body, went there, found that yes, 3 pillar initially made, that was removed. The corporation didn't come up.
Where were the 3 pillars?
My lord, the demolition sketch map, my lord, your lordship kindly once
In the front.
in the front.
In the map where it would be?
In the front portion, my lord. That the arrow, 3 arrows is been made, my lord, to be demolished. This has been demolished.
Do you have the plan? Sanction plan?
না না প্ল্যানটা আছে কিনা বলুন না আপনার কাছে আছে এখন
recasting plan.
রিটের মধ্যে ছিল yes my lord in the writ petition my lord I have annexed the plan. This is the
Now Mr. Chakraborty, tell what we want to say. Now we can take steps to redress your grievance, but if it is your intention that I shall not allow him to raise concern,
that is there already.
That problem cannot be solved.
But kindly check this sanction building plan. This is not a regular sanction building plan. This is for, my lord, if the roof is substantially damaged, it could be repaired by that particular plan. How, my lord, the question of erection of pillar is, my lord, arise?
When my lord,
You cannot raise such things.
yes,
That
that
encroach-
the writ court, my lord, he has not stated.
That is whether, since it is a private litigation, since you have approached in a suit before the court, now you have to show that your personal right has been infringed.
Lordship,
You have suffered some injury
lordship,
on which you have approached.
lordship,
Now your injury that the common passage has been encroached.
lordship, I'm showing.
Unless and until you can show the court that common passage has been encroached,
I'm showing.
you cannot say that
I'm-
there shall be 3 pillars or shall be 4 pillars
I'm showing.
or such and such.
First, my lord, that is a common passage in
H-
my lord, attached to him. It is a common passage first attached to him. Second, there is an encroachment. Till date, my lord, no local inspection investigation has been prayed for.
My lord,
It is only to secure an order of ad interim injunction and to continue with that.
it was done by the KMC and, my lord, come to the conclusion 3
Now-
pillars.
My lord, before the writ court, when I have shown that demolition sketch, the 3 pillars I have erected, I going to demolish. My learned friend was being represented. He could have made submission that no, the entire sanction plan is bad. The KMC could not have made this sanction. His presence, the order is being passed. He has accepted the order. He didn't challenge that order of the
No,
writ
my
court.
lord, kindly consider, my lord, page 18 of my lord, the exception, my lord, that particular here inspection was taken place on 5/9/2023. And that report was placed on the next date, subsequent date. And lordship was kind enough to allow us to file our exception. We have taken on all point in the exception, and I will show the photographs and other details. Lordship will get that information, taking permission under Rule 32E. My lord, he is doing a full-fledged construction, which is not permissible under the law. They are to take permission regularly from the Kolkata Municipal Corporation. And my lord, they are encroaching our common passage.
How can you re-argue the case here, Mr. Chakraborty?
My lord, only after,
This ought to have been your submission before the writ court.
my lord,
In writ court, you should have said that
Lordship,
how this order can be passed.
after this particular disclosure and the report placed by them, they themselves disclose it is under Rule 32E. Previously not.
Lord, he has challenged.
Previously not.
Mr. Chakraborty,
Lordship,
we are in the appeal.
lordship, lordship.
Your argument would have legs to stand
Lordship.
if you could have opposed that in the writ court.
Lordship.
We are here to ascertain whether that injunction in suit must go on or not.
Yes, ma'am.
So if we are satisfied on the basis of the documents that this injunction is no more required, that is why, because why that satisfaction was on the basis of the writ court order.
Lordship. And my lord, lordship, since lordship allowed us to file our exception, let me allow to place it, my lord.
Place
I
it.
shall not take much more time, my lord. Kindly see, my lord,
We
my
are
exception.
allowing you we are hearing it for more than 1 hour.
More than
Lordship, my lord, this particular, my lord, exception I am yet to place, my lord.
Yeah, no,
Lordship
you
raised
placed
certain question. I have tried my best, my lord. Lordship, kindly come to page 9 of my exception.
Page 9.
Page 9 of my exception, my lord, which I have handed over today itself. Lordship got it?
Yes.
My lord, kindly see 115 NS Road at the very beginning. NS Road, my lord, the long road. My lord, beside that 115, my lord, NS Road. Then Lordship will find a portion which is blackened here, and thereafter, my lord, 117 NS Road at the middle of this sketch map. Lordship will find, my lord, 117 NS Road. And in between 115 and 117, my lord, construction is going on. And my lord, they have removed 2-3 pillars, and there are number of pillars are there, which is without the scope of, my lord, rule 32E. 32E, once again, my lord, I repeat and reiterate, my lord, for the repairing of the substantial, my lord, damaged roof. Then turn to, my lord, next page, lordship. Page 12, my lord, page 12. Page 12, my lord.
Portion has been enclosed.
I am showing, my lord, the from photograph. Lordship will find, my lord.
From map in so far.
I am showing map. Yes, my
from
lord, one
map,
second.
then
One
I
second.
am going to.
Once again, my lord. My lord, 115 lordship got it. In
Which
between
road your common passage and which has been enclosed.
in between 117 and 15,
Yes.
my lord, a blackened portion is there. And my lord, round mark is also there.
Where is black input?
3 pillars.
3 pillars. What is the colored copy possible? 3. And the opposite side also 3, my lord. Lordship will find.
Yes.
This is my lord, in the vicinity of our premises. These 3 is yet to be removed. And
your
this
premises is 170.
yes, and in between 2, my lord, the common passage that was being used for a considerable period of time by them, my lord.
This ground floor, backside, tin shed.
Lordship. This one, my lord.
So it is your also, it is your property, or it is the property of premises number
My lord,
117.
this is 115 NS Road backside.
Yes,
And my
so
lord,
it
kindly
is
see.
150.
Yes.
It is not your property. Your 170.
Then, my lord, the open passage, lordship can look at thereafter, ground floor, backside. Then, my lord, open passage is there. My lord, beside open passage, there are 3 number of pillars. These pillars are yet to be removed. And that side pillar,
which pillars have been removed?
my lord, this 115 related pillar, my lord. 115, there are 3 pillars are there.
Who will decide this?
Lordship.
Can we decide that?
No, my lord, the thing is this, my lord, they are doing construction, my lord, without sanction building plan. Well, the other authorities of the KMCs are there. Executive engineer may be, my lord, for some reason, my lord, file this particular report.
What else you want to show?
My lord, I want to show, my lord, the photographs.
Yes.
Lordship will find from page 12. This is the 115, my lord, the old building, page 12, my lord. Lordship will find. And then after, in front of this building, my lord, the construction being made. This is not meant for, my lord, the repair of the substantial damaged roof. Lordship will find, my lord, page 12, old building. In front, Lordship will, my lord, see, my lord, the shuttering. In one part, the other part, my lord, pillars are there. This is also, my lord, the construction. This cannot be done under rule 32E any manner whatsoever. Then, my lord, turn to the next page. The garbage and all this question, and Lordship will find the pillar also. Then I am drawing Lordship attention. Page 15. Page 15, my lord. Page 15, my lord, Lordship will find, my lord, the new construction. And then, my lord, only one opportunity I intend to place, my lord, the rule 32E, my lord. Then, my lord, Lordship kindly conclude the hearing.
আমি দিয়ে দেবো
Judge Sharon. May I hand over other book, my lord?
No, it's okay.
My lord, kindly see rule 32E. Before that, my lord, rule 3, prohibition of erection of building without building permit. My lord, these are certain things are there. Rule 3.2, notwithstanding the provision of sub-rule 1, no building permit shall be required for erection, addition to alteration of internal partition wall and all this. I'm coming straight away, my lord. Rule 3.2e, minor repair and reflooring of an existing damaged roof without changing the character and dimension of such roof, provided that the character of the damaged roof may be allowed to be changed and its construction permitted by permission in writing to the commissioner on such terms as may be considered fit, upon application being made to him with 3 copies of plan on payment of requisite fees and on submission of structural stability certificate from a structural engineer, architect, licensed building surveyor, as the case may be. Provided further, no such work as is referred
reconstruction. You are going to reconstruct.
Yes, ma'am.
Lord, the damaged roof that has been fall down, that is being about to be recasted without changing the dimension. What was previously there, that will be recasted.
So it requires sanctioned building plan.
Yes, that's why not the building.
No, why for repairing the roof, why you need additional pillars?
Otherwise, how the roof will be casted. It
No,
has to
your
be.
room walls are there.
No, now your lordship knows the damaged wall. The roof cannot be casted over there. That was the old building. Your lordship knows the over the wall itself. That will be without pillars. That was constructed 25 inches wall. Today, that will not be possible. That's why this recon.
Now this pillar which has been posted, this is within your portion.
Yes, the corporation found that apart from that 3 pillars, which has already been demolished.
Now how you will raise the roof if the 3 pillars have been demolished?
No, these 3 pillars was apart from the sanction plan.
So
for an additional
you were intending to construct a cantilever over
yes,
this.
so to put an additional structural stability, but that was not allowed to be done. And
Yes.
only one thing, the ad interim order was being passed. Thereafter, I applied under Order 39 Rule 4 for vacating. The initial order of injunction was being passed on a connotation that there is a stop construction notice issued by the corporation. Since at the time of moving my vacating application, still that the stop construction notice was still alive and valid, the court has refused to pass or modify the injunction order, allowing me to.
Where is that order?
That order is impugned before your lordships. That is page 74 or memorandum of appeal. Your lordship will get that order.
No, first order was under appeal before us.
No.
You finish it of this. What do you want to say?
What is more, my lord, I am covered by a division.
That means 3.2e says that
Yes.
for minor repairs
Yes,
or
my lord.
restoring of an existing damaged roof
Yes, my lord.
without changing the character and dimension of such
Yes, ma'am.
roof, no building permit is required. Now the legislature has inserted a proviso
Lords.
for creation some exception. Now, provided that the character of the damaged roof may be allowed to be changed.
Lordship.
That means
Lordship.
without changing the character.
Lordship.
Now there is an exception regarding change of character.
Roof.
Damaged roof.
Damage.
Change of character of damage.
Yes, ma'am.
And is reconstruction permitted by permission in writing of the commissioner on such terms as he may consider fit, upon application being made with 3 copies of plan and such and structural stability certificate from a structural engineer, architect and licensed building surveyor, as the case may be. Yes. So what is your contention?
My contention is, it appears from the last report in the paragraph 2, my lord, they have categorically stated it is, my lord, this so-called sanction is under Rule 3.2e. I put this question to myself, my lord, it is a minor repair or repair of a substantial damage roof. My lord, in fact, they are doing construction over the common passage which have been used by us for a considerable period of time. That being the situation. And I am covered by, my lord, the Honorable Division Bench judgment.
That means they have allowed him to change the character
Yes,
of damaged roof.
Yes, my lord. Not
Upon
only that.
submission of and reconstruction. Upon submission of 3 sanction plan, requisite fee, and the structural stability
Yes, ma'am.
certificate.
Yes, ma'am.
And from a structural engineer, such and such.
It is,
The
that is,
commissioner has permitted them to
my
do
lord, for repairing of damaged roof, which is minor in nature. Is it minor or repairing of damaged roof?
again, you are going to minor.
My lord, that is the, my lord,
That means the legislature says that no building permit shall be required.
lordship.
When? Now, when there is a minor repair or repairing of existing damaged roof without changing, but he will not be permitted to change the character and dimension of the roof. Now there is a proviso that you can change the character
With the permission.
with the permission of the commissioner.
For change, for my lord, doing repairing work of,
You can even reconstruct.
for doing repairing work of the roof, my lord, they require to erect 6-7 pillar, my lord, in the common passage. That cannot be done, my lord. That cannot be. Only, my lord, one judgment, my lord, I am covered by this judgment. My lord, one cannot, my lord, do all these things under 3(2)K, my lord, without taking appropriate permission, my lord, 3(2)E, my lord, 3(2)E, without taking permission from the Kolkata Municipal Corporation.
That's what they have done. They have
Yes.
taken the permission.
No, under Rule 3(2)E. I am showing only judgment, my lord, 6, 12, and 13.
3(2)E has a proviso.
Yes.
So for that additional
Yes.
construction or restructuring,
Yes, my
they
lord.
have got the permission.
Yes, my lord. My lord, once again, the proviso is, my lord, the character of
Is what my brother is explaining to you. 3(2)E, nothing required. But under proviso, it is said that if that sort of construction is you are intending to do, you take a sanction.
For the,
That is why they have
for the
done-
damaged roof only. Yes.
They have taken a sanction to that.
So, my lord, and taking that particular sanction, they are erecting some pillar over the common passage. And that is not permissible. And that
Your
is not
sanction is for the purpose of
Yes, my lord.
3(2)E proviso.
damaged roof.
Proviso. That's why it not require sanction. And only the initial order of
May I refer?
initial order of ad interim injunction is at page 50 of my CAN application, my lord.
You have challenged the order by
By virtue of
dismissing
which, my lord, my dismissal of order 39 rule 4 bracketing.
No, your dismissal of order 39 rule 4 is the order impugned before us.
Only, my lord, 3 paragraph, my lord, may I be permitted, my lord?
Yes.
My lord, para 6, 12, and 13. This is, my lord, 2000 volume 2 CHN 447. 2000 volume 2 CHN 447. My lord, para 6, my lord.
But see the first page.
Lordship.
First page, second head note.
Second, my lord.
Right of a neighbor to challenge sanction of a building plan, disposal of writ petition while hearing an application on how far proper.
Lordship.
This is a connection of a writ
Lordship.
petition.
True.
It is arising.
True.
We are not in a writ petition.
True,
sir.
my lord. True, my lord. True, my lord. But the thing is this, taking permission under Rule 3(2)E, one cannot do certain work which is
Your
required to be
allegation
taken.
is in the guise of a permission
yes,
under
yes.
3(2)E proviso.
While they are doing
You
full-fledged
cannot. That
construction.
is your
Yes.
Yes.
This is my humble submission.
legality and propriety of the order.
With the leave of this honorable court, may
Of the order,
extremely great.
Item number 24.
8th February 20.
24 dated 8th February 2023. Have been called in question in this appeal. The facts leading to filing this appeal is that এখানে হচ্ছে that one
Order impugned. Page 7.
one Devkumar Dey and 3 others institute a suit before the learned third bench, City Civil Court, Calcutta, for declaration and permanent and mandatory injunction. So, along with the plaint, it's an application under Order 39, Rule 1 and 2, read with Section 151 because of the code. Bracketed even herein after referred to as the said application was preferred, contending inter alia that the dependent number 6 to 7 therein, who happened to be the owner of the premises by video number 115 Netaji Subhash Road, PS Borabajar, Kolkata, which stand on the eastern side of the premises number 117. While making construction encroaching the common passage lying in between the two premises. And hence, the residents and inmates of the premises number 117 are deprived from enjoying the free air and light through the open sky
And from utilizing the common entrance.
and from utilizing the common passage to ingress and egress to the premises to and from the premises number 117. So, record reveals that on the said application and 7, who happen to be the appellant herein, filed an application under Order 39 Rule 4 and the said two applications were taken up for hearing or heard analogously, along with another application under section taken out under section 151 of the code, seeking extension of administrative order of injunction.
Initially passed on 4th March 2020.
Administrative order initially passed on 4th March 2020.
Next class.
Upon hearing the respective parties and upon perusal of the records,
The administrative order was extended and
the application under Order 39 Rule 1 and 2 of the code was allowed, and the application under Order 39 Rule 4 was rejected on contest, and the defendants are restrained from giving any effect and further effect to the sanctioned building plan, and the defendants are further restrained from making any construction or further construction at the suit premises
from encroaching the common passage.
Encroaching the common passage in Schedule B, I mentioned in the Schedule B, till the disposal of the suit. So, Agreed,
The appellant's application.
আগে বলে দিয়েছি। আচ্ছা আচ্ছা, agreed by the said order, the dependent number 4, 6 and 7 they are to preferred this appeal.
Only my lord, dependent number 6.
আচ্ছা, dependent number 6 has preferred this appeal. Yes. Inter alia on the ground that the learned court below did not consider that the appellant made construction on the basis of a building plan sanctioned by the competent authority, and since the building was in dilapidated condition, so there was a requirement for reconstruction of the such building, and accordingly the appellant undertook such reconstruction work, and so and the learned court below has crossed over this issue and did not return any finding on those issues. Stop. Mr. Mukherjee, learned advocate, appearing for the petitioner, submits that admittedly the building was declared to be a dangerous building, and the corporation concerned gave a notice asking the appellant to reconstruct the building, and the damage of the roof of the building was badly damaged, and hence for reconstruction of the damaged roof, the petitioner submitted a building plan before the corporation, and after following all the procedure, the corporation permitted the appellant to reconstruct the damaged roof. Drawing attention to the order passed by this court in a writ petition where is there?
Lord, page 5 of the supplementary affidavit.
He submit that a single bench of this court got occasion to intervene into the dispute, and in a writ petition as preferred by the one of the appellant, being WPA 8598 of 2023, which was disposed of by directing the executive engineer of the concerned borough to cause a spot inspection upon notice to all the necessary parties, and prepare a sketch map and forward the same, so that step could be taken to demolish the unauthorized construction by the petitioner. He submits that in compliance with the order passed by the learned single bench in the aforesaid petition, the inspection was made, this sketch map was prepared, and the unauthorized portion, unauthorized construction was demolished, and after demolition, a joint inspection was held on 8th September 2023 in presence of one of the plaintiff. And the concerned official of the KMC, after being satisfied that the unauthorized construction has been demolished, withdraw the notice, stop work notice. Withdraw the stop work notice and stop the demolition proceeding. He submit that taking note of such subsequent event, taking note of such subsequent event, the interim order should be set, the order interim should be set aside, and the appellant should be permitted to continue his construction work, since the building is a dangerous building and is a dilapidated and still in dilapidated condition. Stop. Mr. Chakraborty, learned advocate, appearing for the
Number 1, plaintiff.
3 and 4. Plaintiff respondent.
Plaintiff. 1, 3 and 4.
1, 3 and 4.
Submits that the only 3 pillars have been removed, and there are other pillars which have not been removed, and the portion which were encroached.
In the guise of the sanction plan, please raising fresh construction.
And in the guise of making reconstruction of a damaged roof, they are making a new construction. He submits, Mr. Chakraborty further submits that here the permission to reconstruct the damaged roof was given by the concerned official of KMC in exercise of his power under Rule 32E of the Building Rules of 2029. But in exercise of such power, permission cannot be accorded to make a fresh construction. Construction. He submits that the KMC has acted in violation of the building rules. He submits that if the interim order or order interim are set aside, the respondents number will be highly prejudiced. Stop. Mr. Vishwas submits that in compliance with the order passed in the writ petition,
Such for KMC.
in the writ petition, joint inspection was held. This sketch was prepared, and the appellant removed the construction which made in deviation of the sanctioned building plan, and thereafter joint inspection was made, and the KMC was satisfied that the unauthorized construction, the portion which was constructed unauthorizedly, have been removed, and thereafter the demolition proceedings has been dropped and the stop work notice has been withdrawn.
Joint inspection was held in consonance with the order passed by the
Joint inspection was held in consonance with the order passed in the writ petition. Stop. He submitted a report as produced by Mr. Vishwas. Is taken on record. Stop. Further learned advocate, peruse the other materials, peruse the materials on record placed before us. Stop. admittedly, here where a single bench of this court intervened into the matter after the interim order passed by the learned court. And in compliance with the said interim order, and joint inspection was held, a D-sketch map was prepared, and the appellant hearing removed the unauthorized construction, and thereafter he informed this fact of removal to the concerned official of the KMC, and then again a joint inspection was held in presence of one of the plaintiff. Then, on being satisfied that the unauthorized construction has been demolished, the demolition proceedings has been dropped and the stop work notice has been withdrawn. Stop. The plaintiff respondent was present during joint inspection. They did not make any complaint to the effect that any complaint at the time of joint inspection. Even they have not made any, have not challenged that this sketch map, and they have not prepared any appeal under section 400 within bracket 3 of the Municipal Act. Taking such subsequent event in consideration, I am considering the facts and circumstances of this case and the argument advanced by the respective parties. We are of the view that the 39(4) ওই লাইনটা তুলে দেবে, ওই যে তুমি বলো সাবসিকুয়েন্ট চেঞ্জেস, তোমার সিবিসিটা 39(4) ওই লাইনটা আছে সাবসিকুয়েন্ট ইভেন্টস আর প্রেজুডিস। কখন করতে পারে? By change of circumstances. We are of the view that there is no necessity of continuance of such interim order. Stop accordingly.
My lord, one submission, my exception can be recorded, which was filed today, my lord, my exception.
Exception file exception ওটা রেকর্ডে নিয়ে নেবে, ঠিক আছে? এক্সেপশন ফাইল করেছে, রেকর্ডে নিয়ে। ওকে, সেটা সেট করে দেবে। In view thereof, the order impugned in the appeal is set aside.
And my lord,
And the appeal is disposed of.
only one thing, my lord. Statement made in paragraph 19 in page 7 of the exception is contrary to the document, my lord, submitted in page 18 of the exception. The statement made in paragraph 19 in page 7 of the exception is
Yes,
contrary
you have
to
told
the.
us that. You have
My lord,
told us.
my lord,
We have
that may be.
we have recorded that your spot inspection was held subsequent thereto.
And appellant is not permitted to raise construction. Not
Vacated, we have vacated the injunction.
Fine.
এটাই তো চাইছি। Injunction-টাই তো চাইছি, হ্যাঁ? মেমোটা দাও না। মেমোটা কোথায়?
আমার কর্পোরেশনের
আরেকটা আছে।
বইটা আছে আমার corporation।
হ্যাঁ হ্যাঁ আরেকটা আছে দুটো।
But I appear for this thing.
Finish what he has.
So report your lordship has asked report.
Pardon?
Report from the Lord this CIG.
Was.
As per your
The
lordship's
report
direction,
খুলে দাও।
you may be permitted to file the report. এটা discussion. এই নামটা এইদিকে দিয়ে কেন
দেখো what ধরতেও পারবে। Now Kurban and Lodhai is being represented by Mr. Moitro.
And Mr. Moitro.
And he is representing you are representing Chimu. No development, Mr. Banerjee. No development.
But development blood actually no development, but blood the efforts were taken, Lord, your lordship kindly see.
How many?
Time and again. But Lord, but we are actually, we have tried our level best and trying our level best. Even Lord, the technical informations are also received by the Lord, the department. And we are trying our level best. Lord.
Property is there in the name of this Kurban Ali Mandal? That you did not assert it.
Property?
Nothing is there in the report.
No, my Lord, this is in the report. There is no whisper about this.
No whisper.
No property.
All conducted rate.
No.
Stereotype answers given. Why don't you call your officer and appropriately deal with him?
But officers are here. Officers are here.
So you check up the report, but this is reiteration
I
of
have
the
checked.
earlier. See?
I've checked.
Reiteration of the earlier report. 4 times, 5 times directions are issued, and then your competence is in doubt.
Earlier report, before earlier report, but there was the arrest of another person.
That was one person. But so far as this is concerned, it is like
out of 2, Lord, 1 person arrested.
so then it
No, Lord,
speaks about
that is,
the
I'm not taking alibi of that. I'm not taking alibi of that.
Yeah,
Your Lordship is absolutely correct. Absolutely correct. Lord,
So
Lordship.
it speaks about the competence of what
My Lord, I will sit with them, Lord. I'll sit with them. As your Lordship, Lord.
as it has fallen from
My Lord, my Lord.
No, it is very elementary. If I do not get a person, let me find out whether he has any property or not. A very elementary thing. For this, nothing extraordinary is required.
But Lordship, kindly pardon me, Lord. I will sit with them, and I'll come with the positive report. I'll come. Lordship, kindly pardon me for that. আমাদের রিটায়ার করান থেকে নিয়ে
Sanjay, this Pute
did not come.
He did not. Arrest করেছে।
হ্যাঁ
Banerjee, we are asking your Home Secretary to do take up. We are very dissatisfied with the manner in which it has been done. Let the Home Secretary come into the picture.
Only don't take me amiss, subject to your lordship's kind sanction. Your lordship has asked me to sit with them, but I have already told them, lordship, kindly give me one chance. One chance. One chance, being an officer of the court, I desist to your lordship. Kindly give me one chance. Then your lordship kindly pass the order. I'll not stand in the way. Kindly give me one chance. Let me come with the positive.
This will go on delaying the.
No, not delay, with folded hand, I'm tendering apology. Lordship, kindly give me one.
See, Mr. Banerjee,
I have understood, I have understood, I have nothing to say, nothing to explain. I have no language to explain. Only, I beseech, to your lordship with folded hand. Kindly pardon me, and I tender my apology. Your lordship, kindly, give me one chance. Give me one chance, then your lordship pass the order. I will not stand, and I will retire from the brief also. I have just now told him. I will retire from the brief. Because I am the last person to play with the court. CID department কে বলে দেবেন এবারে যদি হয় আমি কিন্তু রিটায়ার বলে দিলাম রিটায়ার করে যাবো কোনো
4 or 5 pages detailing so many things which were never proved by the prosecution, that those chain of events. So my point was conspiracy angle not proved, conspirators acquitted, their acquittal not challenged, and the retracted confession
Yes.
being a very weak piece of evidence cannot be relied upon.
Yes.
Second point was effect of acquittal of those accused persons upon the section 396 of the Indian Penal Code. In respect of Chimu Sardar, because I had humbly submitted before your lordships for 396, the language is dacoity with murder, although it is not necessary to be specified actually who had murdered, but if I may only just for the sake of the argument, just read that portion, 396 IPC, relevant portion. (396) is dacoity with murder if any one of 5 or more persons who are conjointly committing dacoity commits murder in so committing dacoity. In the charge, your lordship remembers kindly,
Yes.
charge was actually framed that was also defective because 14 persons were together charged. Conspirators were separately charged and the persons who were absconding, they were also separately charged. But even then, out of those 14 persons facing the trial, including the appellant, Chimu Sardar, if it is alleged that they conjointly committed dacoity and in course of commission, they committed murder, in my humble attempt, I tried to show that it was not very clear as to how many persons were present at the place of occurrence.
Yes, yes, you have argued that.
Yes, and
that was the initial argument
yes,
of Mr.
that was the
Hon'ble.
initial argument in the sense that if 14 persons have not committed the murder, out of them, then it can't be so easily stated that 396 will be attracted. Because
17 acquittal was there.
yes,
Yes.
because some other person, if they were present and another angle, as it was noticed by my lords, that ballistic report was never proved. Ballistic report was perhaps part of the LCR in some other trial in respect of some other person whose fate we do not know. One single person, I had pointed out to that, and my lord, unless the weapon is seized from any of the present appellants, it can't be stated, taking the aid of test identification parade, that somebody saw that Chimu Sardar, not Chimu Sardar, nobody named me, said some person of short height was roaming around with a gun. I've read it once. With a gun, somebody stated, but no gun was recovered from me. Therefore, who was that short person was never conclusively identified. Only stated that somebody was, and another angle I noticed last time, if your lordships kindly see the judgment, 2 persons were relied upon identification by the learned judge. One was the lady, another was PW 59 who was present. These two, out of these 2 persons, there is also serious discrepancy in the sense the lady stated that the driver of her bus was killed and that person, another witness stated, driver of his bus was killed. But the way they narrated the incident, it appeared none of them were witness to the murder. If your lordships kindly see their evidence portion where they stated, narrated how the bus was stopped and how firing was done, your lordships will find discrepancies that they do not tally.
Yes.
So what I mean to say, as I had earlier tried to say before your lordships, that the investigation was not done in a proper way. They should have, what they should have done, they had alleged that 2 buses were stopped, thereafter Tata Sumo and also 2 cycles. So they could have sought for a systematic identification saying that these were the persons present in these buses, and in this fashion never the examination was done. So there seems to be a bit confusion as to who was in that bus, and never they had specified by bus number these two witnesses in which bus they were. Even if we think that they were present in the bus where the murder was committed, it appears from the difference in their version that both the ladies and the witness can't be in the same bus. Your lordships will kindly see that portion, and it seems that their evidence is not very convincing. So far as
No, that
awarding
is- that-
conviction,
That is not within your points.
that is not last year
You argued that
my lord,
earlier.
my lord.
Yes, which judgments you are saying? Look
My
into?
lord, two more points, two or three, just kindly allow me one. Effect of Bablu Bala being separately charged, whose trial fate is not on record, being charged with 25-27 Arms Act. My lord, this person's trial was being proceeded. We do not know what is the fate, but apparently I found 25-27 was the section against him. So we never know whether he had fired or like that. Because it had a bearing on the present trial, this Bablu Bala. That is my third point. That the prosecution never tried to highlight before your lordships in the present appeal. So as to who fired, unless out of the 14 persons charged, if none of them have fired and from none of their possession gun was recovered and ballistic report is matching, then probably they cannot attract 396 so easily. 395 they could have, but not 396, because conjointly committing, that conjoined word won't come unless they can be said to be in the same transaction.
Yes.
And fourth one was the non-recovery of the offending weapon. Your lordship has already noted. Absence of ballistic report. Also, my lord, to verify inquest and postmortem report, not exhibiting forensic report. These were never done. Forensic report was also not exhibited in the present case. Fifthly, absence of reliable depositions in respect of 354, 376 2G IPC, resulting in acquittal. Here my point is, when the portion of the events as evidenced by the deposition of the victim girls, victim ladies, saying that, I'm not saying what discrepancies, I'm saying simply that the learned judge did not fit it prudent to rely upon them. Now, if the ladies, some ladies stated, your lordships will find some of them stated the male persons were outside the bus. The male persons, including the person upon whom reliance was placed by the learned judge, he said, we were asked to board the bus. And your lordships will find there is a discrepancy as to who boarded the bus and as to the assault upon victim ladies. All these things, perhaps, my lord, weighed upon the learned judge to hold acquittal. Now, the moment the offense upon the victim ladies are being doubted, a portion of the prosecution story that in the same course of transaction, while searching for valuable articles, they were molested, thereafter they were dragged. The moment these things are disbelieved, I'm saying humbly that prosecution story gets a jolt. So this will go in the favor of the, because some portions remain not proved, if not disproved. And then absence of light, as argued by learned senior counsel, there was no conclusive evidence regarding presence of light inside the bus and regarding covering. Learned advocate Mr. Mondal has stated already, so I need not repeat. So these things never make it safe to place reliance on identification. And this was my specific point, 412 IPC. There was no specific statement of acquittal in the final portion, but learned judge specifically stated 412 was disbelieved. So if 412 is disbelieved, then starting from conspiracy, if your lordships, even if once go through the retracted confession, your lordships will find the conspirators allegedly tried to procure persons in order to get the offense done, and they never tried to, in the conspiracy, never 376 charge was there. conspiracy was for 395 only. For that 120B was there, also not 396. So the moment conspiracy fails and also the recovery of articles fails, the entire prosecution story also fails, in my humble understanding. Because 412 was specifically not proved. Although each of the persons were shown as receiving one thing, somebody received some ornaments, something, each was shown to be possessing something. So this was disbelieved by the learned judge. The moment this is disbelieved, the prosecution has to explain where from these things went into their possession. If they fail to establish 412, then they perhaps cannot rely upon 395. Because it was an essential part. Dacoity is made for looting of the articles. This is it is not only for showing intimidation, but for making some material gains. Now, if material gains are not proved, perhaps the crime also gets doubted. 395. And another thing which is not related with the appeal was my last point regarding their how much of time a person can be kept inside. I humbly keep this for your lordship's kind consideration, because already perhaps more than from 2003 they are in custody. Effectively, they are in custody for 20 years, and if some remission, your lordships know, and from Honorable Appeal Court judgment, I found it counts around 2 years. So around each of them around 22 years in custody. That they can be, their conviction can be upheld from this angle also, because already 22 years they are inside, more than 14 years from this. So how much evidence is strong enough to warrant their further punishment? These are the angles, and your lordships were kind enough to allow me to argue on 395 number of persons. I'm not relying on those things again. And the entire evidence, it appears, if your lordships kindly see the judgment, the learned judge scanned through everything, but things suffered a jolt from the people getting hostile. Now, what was the reason for hostile? Nobody knows. But the moment people get hostile, unless the prosecution asks specific questions to say they are, what is the reason to unearth that, they cannot rely upon the hostile witnesses. And the first person who could have stated was the conductor, who was the FIR maker, and he himself went hostile. And the persons who claimed to be in the bus, they never specified in which bus they were inside. And somebody stated we were up on the roof of the bus, but there was no ladder or like that. Even if we think that there was ladder, from above the roof, it is not possible to see what happens to inside the bus, because the victim ladies also were not very consistent with their version. Somebody stated I was dragged outside the bus in a bush. Somebody stated she was standing behind the bus. Somebody stated, yes, somebody stated she was inside. She was touched inside. So I'm just saying, even if their versions were at some stage believed, the corroboration from the so-called male passengers who were asked to be segregated is not coming, because it is alleged that they were segregated. And as to who fired, that never comes. And the most vital thing, I believe your lordships will kindly consider the non-seizure of the offending weapon, which is the main thing, because a dead body is there, somebody has received something, post-mortem report shows that somebody perhaps has received gunshot injuries, but they are conducting the trial in a very what I call very slipshod manner, that they are not very much, I do not find it very efficient way they had done it. Though, although this thing had perhaps required some more efficiency.
Anything else you want to show?
No, my lord, this is the...
Show us the judgments.
Yes, my
which
lord.
paragraphs?
My lord, the judgments I am grateful for. My lord, the first judgment I relied upon was past judgment was, my lord, actually was the last one relied upon by me, where Honorable Appeals Court, where Honorable Appeals Court has stated,
Citation.
my lord, it was 2023 live law
Huh.
within brackets SC 238.
Huh.
My lord, there Honorable Appeals Court stated that the all those under trial prisoners and convicts were released on parole, but or interim bail pursuant to recommendations
Which
of,
paragraph you are reading?
my lord, the very first one.
What has this to do with you?
No, only thing is that I may I just one line, my lord. Only thing is that their lordships found that pursuant to Honorable Appeals Court judgments, they were released, and they never surrendered. Only thing that their lordships found that no separate cases, or by implication.
This was during the COVID times.
Yes, my lord, they were released on COVID time, perhaps, if I'm not wrong, because perhaps they did not surrender after being released on COVID time. So whether they can be subject to lordship's kind permission if released on, I do not know on which ground they were released, but if on COVID ground they were released, Honorable Appeals Court allowed them to come back into the fold.
What is your point to substantiate by this? What is your point?
No, my lord, point is that because they are facing the prospect of jailbreaking also, because during the argument of the criminal appeal,
Prospect of jailbreaking
means
that they will break.
yes, my lord, they did not surrender. Perhaps the CID has issued proclamation and separate
They
cases.
have done nothing. This report is absolutely silent on those things.
Initially, when your lordships directed, my lord, perhaps they had started specific 3 cases or maybe more. I do not know that report.
That's a separate case.
Yes,
That's
but only
absolutely-
I was just pointing out that it due to COVID, it did not surrender. Honorable Appeals Court
on that matter.
allowed them to go back just for that, not regarding merits. This is the one. Because even if they get some advantage in the present appeal before your lordships, they will never be able to see the light because of that charge, if at all they have started any case. That is the thing.
That is
So,
not a relevant point.
All
of
right,
to
all
argue
right, my
here.
lord, I leave this, my lord. Now, my lord, the judgment. My lord, the next judgment is that Hori Shankar versus State of UP. That is reported in, my lord, that is a judgment of 2015, my lord.
Pardon?
That is a report of 2015.
Reported in what?
My lord, I got it from
You have not
the website.
paginated, you have not paginated this spread from we can find your judgments.
Yes, man.
Give the title of the or what is the
My
title?
lord, the title is Hori Shankar versus State of UP.
Gauri Shankar.
Hori Shankar versus State of UP.
The reported or unreported? Yes. Hori Shankar versus State of UP. Yes, what do you want to show?
My lord, it was found that if the evidence is unreliable, the charge can be scaled down.
Paragraph.
My lord, the last paragraph your lordships will find from 302, conviction was scaled down to 326 only.
Yes.
So only regarding that if the evidence or proof required for 302, 396 or 395, whether it can be scaled down.
Yes. Next.
My lord, the next one is although judgment of Honorable Allahabad High Court, Lokai Chamar versus State of UP.
Yes.
My lord, there your lordships will find for non-examining the London magistrate who held the TI parade and absence of independent incriminating materials, acquittal was recorded. In a 391 read with 396 IPC.
Which paragraph you are relying?
My lord, the page is inner page 14, paragraph 46.
There is no paragraph 46. Yes.
And 47. 47 also. Weapon of offense not recovered, and 46 is TI parade not properly proved so far by examining the learned magistrate. And the last paragraph is 52. Conviction and sentence being repugnant to letter and spirit of 391 and 396, liable to be set aside. Then the my lord, that Horishankar I had relied. Horishankar, my lord, I have again given that judgment. My lord, the reasoning and conclusion, paragraph 13, your lordships kindly note. Their lordships held.
You have finished with it. Paragraph 14, you relied for scaling down the charges. You have finished with
Together
the
with that
judgment.
paragraph 13 also. 13 also.
Yes.
My lord, there 13, their lordships held if co-accused persons are acquitted and their acquittal becomes final, then conviction of the appellant with the aid of section 34 IPC would be untenable.
Yes.
Chakraborty, you are not ready properly.
Yes, my lord, actually. Actually.
Candid confession.
My lord, actually. My lord, actually, I missed it. I thought it is fixed on 12th or like that. Actually. It is the reason.
No, you have finished your argument.
Only the
So-
judgments I could not properly.
No, judgments you have referred to, you have just give us the paragraphs of the judgments finished.
Man,
We will go into it.
My,
Next you come, refer the paragraphs, we will mark.
my,
And that's all.
Yes, Mr. Vance.
I shall please not the judgments of the Honorable Apex Court regarding Lord
For information. একটি অবস্থায় চলছে এইটা না যে রিপোর্টটা সিআইডি রিপোর্টটা যেটা আজকে ফাইল করেছে হোম সেক্রেটারিকে পাঠিয়ে রাখো
আমাদের আগে জাজমেন্ট দেওয়া আছে তো
কমিশন অফ স্টেট অফ অ্যাফেয়ার্স
our judgments earlier and one judgment Lord
You have placed 57 Supreme Court, 71 SCC, 2003 Volume 5, 2008 Volume 11.
my lord I'm
Four
Lord
judgments.
one judgment yes 390 কোনটা কোনটা সেটা দাও
একটু সাইটেশনটা বলবে দাদা
কোথায় যাচ্ছে তো বলো চারটে করে another judgment we have placed Lord regarding Lord 376
Oh, acha, 2016 SCC. Yes, yes, yes. 376.
আচ্ছা সুমনের কাছে আছে দিয়ে দিচ্ছি সুমনের কাছে আছে দিয়ে দিচ্ছি I'm not
No,
the
these-
only one judgment Lord we shall place today regarding Lord the
No, this you please say 2006, 16. You relied upon it for what?
আগে দিয়ে তারপর দিচ্ছি হ্যাঁ
You relied upon it for what? What proposition?
today's your lordship is asking 2016
Yes.
16 or my lord today's judgment
No. 2016 you said.
376 376
Which paragraph you are?
my lord I'm giving huh? But 376
Hey,
my lord,
copy to the- You don't have a copy?
no copy is we have 376 my lord, that is my lord,
Please check up.
injury
This is
yes.
the judgment you are saying.
নম্বর আছে হ্যাঁ প্যারাগ্রাফটা জিজ্ঞাসা করছেন blood paragraph 8
Para 8.
slightest blood degree of penetration if there is there blood disease 76 will lie blood paragraph 8 without any injury দেওয়া আছে জাজমেন্ট দেওয়া আছে 2070 পাচ্ছ না নেই হ্যাঁ ওর ক্লার্কটা কোথায় গেল
Yes.
গন্ধমাদন নামিয়ে দিয়ে চলে গেল today Lord we shall place the judgment regarding Lord the 395 whether Lord the below 4 persons whether charge is Lord your lordship kindly Lord allow me to Lord I'm placing this judgment param Lord এটা para 15 টা হচ্ছে ইয়ে না হ্যাঁ Lord para 2 12.1 para 2 12.1 14 15 16 and 17 Lord may I repeat Lord para 2
Just one.
12.1
Just one moment.
সাইটেশনটা হচ্ছে তোমার সাইটেশন দিয়ে দাও না
থ্যাংক ইউ
তখন থেকে
Yes, paras.
para 2 12.1
Yes.
14
14.
14 15 16 and 17 and Lord the 15 if your lordship kindly allow me to read Lord I can read but may I read Lord
Yes.
even otherwise there is no difference between section 391/395 and section 397 IPC so far as the sentence stroke punishment except the difference in case of section 397 IPC the punishment shall not be less than 7 years Otherwise, the robbery and dacoity are sine qua non. Dacoity is nothing but an exaggerated version of robbery with a difference in number of accused. Therefore, also even in a case where the accused is not convicted for the offense under section 397 IPC, still he can be punished under section 395 IPC, and no prejudice shall be caused to him, as ultimately the prosecution has to prove the robbery and dacoity either for the offense punishable under section 395 IPC or under section 397 IPC. Lord, however, to bring the case against the accused under section 397 IPC, the prosecution has to prove one additional fact, that the offender has used any deadly weapon or has caused grievous hurt to any person or has attempted to cause death or grievous hurt to any person. Therefore, the case is made out under section 391 IPC read with section 395 IPC. Despite the fact the courts below convicted the accused under section 395, which is held to be unsustainable in that case, and also if the case is made out under section 391 IPC read with section 395 IPC, still they can be convicted for the offense punishable under section 391 read with section 395 IPC even altering the charge. As observed herein above, in the present case, the learned trial court framed the charge against the accused for the offense under section 395, 397 IPC both. Now, so far the submission on behalf of the appellant accused that even no case is made out for the offense under section so and so, they cannot be punished under section 395, as what is required to be proved is involvement of 5 or more persons conjointly in committing the robbery, and in the present case only 4 persons are tried and the prosecution has failed to prove the involvement of 5 or more persons. However, it is required to be noted that as such in the FIR there was a reference to 5 persons involved in committing the robbery. Even the charge sheet was filed against the 5 persons. However, as 2 accused absconded, the trial was split and 3 accused came to be tried. 1 accused, Benny, came to be tried subsequently, and 1 person is still absconding. Even there are concurrently findings recorded by all the courts below that 5 persons were involved in committing the offense of robbery merely because some And here in this case plot, here in this case also, plot the Urban Ali, when plot the 25 or 28 witnesses have been examined and trial commenced, plot he was arrested. And Lord, your Lordship kindly consider 2 things, the Lodha Saddar and Lord the Chinu. Both were identified in the TI parade as well as in the dock. And Lord, so far as the light, Lord, I have already submitted.
Question is not whether this person is identified or not.
My
Question is whether persons are identified or not. Question is whether there are 5 or more persons who are there. They might not be identified.
Keep it. 16.
What is the point discussed here?
What is required to be considered is the involvement and commission of the offense
Yes,
of
there are
robbery.
5 or more persons who are there, present on the spot.
But in this judgment, it has also been held. This where 1 person has been acquitted, therefore.
Yes. Point is 5 or more persons are there. If that is proved, then if 2 are absconding, 3 are absconding, that is no issue.
Here, blood 5% charge sheeted, 1 acquitted. 5% charge sheeted, 1 acquitted. That means blood the 395, 397, 395 should be there. There is no
5%.
5% charge sheeted, 1 acquitted, and 1 absconding still now. Urban Ali. Here, Lord, in this case, case I have referred before your Lordship.
What this judgment?
5% charge sheeted, 1 out of 5, 1 acquitted. But even then, Lord, the charge of 395 was also there. Lord, it
What
was
the judgment proposed to say is that if the 5 are there,
My,
or say 6 are there,
my lord.
and one is acquitted.
Yes,
And this acquittal does not prove
my lord.
below 5 persons were there.
My lord, my lord.
Then it will continue.
My
Charge
lord,
will continue.
my lord. Deeply obliged to you.
For some other reasons, he might be acquitted.
My.
But question is whether
95 would be there or not?
proof that 5 persons were not
My-
present.
my
That is
pers-
the decisive factor. That is this
My
point.
lord.
And that is your point of argument.
But this is my submissions, Lord. I have already, Lord, and written notes of arguments we have
So
already.
what is your statement to the identification and retraction of identification? Because Mr. Mondol's submission was, first of all, as regards recovery, has stressed upon that there was no recovery, 7 except that silver ring. First point he argued. Second point he argued was how on the basis of it, a weak piece of evidence, this retraction of this confession, whether that can be the substratum for proving the charges. To that, do you have to add anything?
Lord,
Retracted confession is also admissible.
Lord, we have already, Lord, regarding confession and retracted confession, we have already, Lord, placed the judgment. Lord, that is 1957 Supreme Court 216 Balbir Singh.
Balbir Singh.
4 judges bench.
Yes, yes.
We have already, Lord, that is that will not.
So you are relying upon that
My
judgment
Lord,
for the
my Lord.
purpose.
Even then, Lord, it will, the punishment can be given. Huh? Page, yeah, 1957, Supreme page 216.
Thank you, sir.
Solo. Balbir Singh. And Kurban Ali's confessional statement is also there. After arrest, he has confessed before the Lord, the land magistrate. He was produced and he has confessed.
Yes.
But that is my submission, Lord.
Mr. Mondol, you want to?
Yes, my lord, so far Kurban is concerned, my lord, 164, only 164 conventional statement is. No other evidence is there. No witness utter name so far Kurban Ali is concerned. No identification, nothing, no recovery. So far Kurban Ali is concerned. One evidence asks my learned friend, except 164, any evidence against Kurban Ali. Thereafter, any circumstance.
If I confess before the
Any
court, I have
circum-
committed the.
My lord, any,
If I confess
that's
before
why,
the court.
so far, my lord, I have also relied on judgment, my lord, on this regard. My lord, my asking myself, my lord, so far, without confessional statement, no recovery, no, my lord, identification, even in court, nothing against this, so far Kurban Ali is concerned. And so far Lodhai is concerned, my lord, initially, there is no allegation so far 376 is concerned. Subsequently, my lord, CID took over investigation, entire episode changed. But there is a gang rape also. My lord, so far other, my lord, victim is concerned, they are not identified, they are not support the prosecution story also. And not only that, my lord, so far 59, they never 161 statement recorded by any, my lord, investigating officer, and no 164 statement, and not even he was placed to before the TI parade. He identified Lodhai, but my lord, what is the act? My lord, nothing say before the learned judge also when TI parade was had. And so far medical is concerned, that's why I, my lord, and my lord, so far specific, my lord, evidence ta koto bolo, PW.
No, 117
My lord, 113, 1 second.
No, Mr. Banerjee, he has extensively argued on
Yes.
these issues. What is your reply?
Yes.
I cannot develop the anything.
No. Can you show us anything that this
So
statement?
far as my submission is concerned, Lord, we have already stated in our written arguments also. Confessional statement before the Lord, the learned court magistrate.
No, that ground you have taken.
But
Because
except nothing is there, but Lord, I am harping on that. If I confess before the court, I have committed that, but Lord, this is sufficient. This is sufficient. But I cannot develop because there is nothing except that 164 statement, because he was arrested at the very belated stage. Because when 28 examined and everything, because we have no scope to for TI parade or something like that. Because 28 witnesses examined. Thereafter,
Was placed on trial in presence of the accused person. That evidence has been taken. Before court, he is the person. He was present at the time of doco investigation.
after 28 witnesses examined,
Not
arrested.
identified in court.
was arrested. Court. Court to ही हुई. Para 7.
কোনো উইটনেসই নেই, সব ডিক্লেয়ার হোস্টাইল।
In our written notes, my lord. বললো পরের দিন পিস নিয়ে সবাই খাওয়াই গেল এই মামলা নিয়ে চলছে যৌথ কনজয়েন্টলি কনজয়েন্টলি রাবারিং কনজয়েন্টলি
one mistake I have done.
লেখা থাকবে
In my
Now কি বলবো বলো?
I have made a mistake. I written notes on my page 7, running page 7. 58 also declared hostile who identified the one of the accused person.
Not
58. Not our accused. 58. All vital witness declare hostile. 58. I am not written it. Yeah, it's my mistake. He is also declared hostile. FW8. All vital witness declare hostile. 58. Yes, ma'am.
I'm Lord, in our written notes of argument, page 7, paragraph 7, we have stated regarding Kurban Ali Mondo. The appellant Kurban Ali Mondal was arrested in connection with the case of Spenso police station on 18 March 2004. And he was interrogated by PW 138, that is Tapon Kumar Das, on 22nd March 2004, made a prayer before the learned SDGM Howrah for the purpose of producing accused Kurban before the learned SDGM at Ranaghat. In connection with Dhantola police station case number so Kurban was produced before the Ranaghat court when trial has already commenced and 28 prosecution witnesses have already been examined and therefore he has not been placed in TI parade. But he made the confessional statement before the land magistrate. But that was relied upon. Lord, this is my submission, Lord. If I confess before the court, I have committed. Whether, because confessional statement, the evidential value, your lordship kindly consider. এটা তো রিট্রাক্ট করেনি
করেছে retracted.
It is retracted confession. It is not confession, rather retracted confession.
So far as the retraction of the confessional, blood, I have already cited the judgment of the Honorable Supreme Court, 1957. Yeah, 1957, Balveer Singh case. And another judgment, 1971, second judgment. Regarding Retraction lot 1971 also I have given, 2 judgments. সবাই খাবো এখানে। সবাই খাবো, নিয়ে আসবেন এখানে, মামলা দেওয়ার আগে দিয়ে দেবেন। এই বলে দিয়েছি, এখানতে বলেছি মামলা দেওয়ার আগে সবাই খেয়ে নিয়ে গেছে।
ordered portion of
See, we are keeping it on. কবে বললে যে কত তারিখ?
এলসিআরটা একটু দেখে LCR আমাদের কাছে তো এলসিআর নেই, ও বলছে দেখেছো।
কেন 19
শিওর
Mr. Banerjee, we are keeping it on 17th. If no, we do not get any response from your end for as regards this Kurban.
Only 17 there is a special bench is there, I'm told.
না ও বলছে যখন
But regarding the anticipatory bail of juvenile, that special bench is
We are keeping it on 18th at 3 p.m. We finished it off.
বিফোর পূজা তো,
Huh?
হ্যাঁ শেষ করে দাও।
19th is the last day.
19th last day. 18th we have kept. We have finished, argument has been finished. He will give us the judgment reference, and if Mr. Mondal wants to give anything in reply, we will hear that. But so far as
there
your
is no
report is
reply.
concerned,
So far
if you do not, we would be constrained to pass some direction upon the Home Secretary. Otherwise, it becomes very disturbing. In spite of repeated there,
Yes.
as my brother has said that there was no endeavor on your part also to ascertain whether he has property or not, whether it can be taken up or not. No force, nothing. What the DIG is doing.
Cholo,
may call in the court the Home Secretary.
my lord.
We may call for the Home Secretary to be present in the court. Next day, personal appearance of Home Secretary. Would me pass order.
Kindly record, my lord, we have finished our arguments. We have finished our arguments, kindly record.
তাহলে what is the need for next day? You know,
no. I written argument also.
Oh. তুমি আর বলবে কি? তোমাকে বলছি
আমার কিছু বলার
বলে দাও, তোমাকে তো বলতে বলছে মন্ডল যদি বলে।
আমি তো না বলে
Mr. Mondal is saying he has nothing to say.
He has nothing else to say. We are reserving the
My
judgment.
lord.
Yes.
My lord, then it will be difficult for me to hand over that.
Hand over before the court officer.
Hand over to our court officer.
Yes.
Any day you hand over to our.
Because your lordships are not sitting, I don't know whether the file is here or not, whether I can.
That is court.
The Chakraborty, number of attempts were made, number of opportunities were given. If you are not able to do so,
Then kindly,
পরশুর মধ্যে দিয়ে দেন।
my lord, then kindly allow me to hand over that judgment.
On Monday দিয়ে দে।
No, that judgments you have taken our copy. You don't have a copy.
I had copies, my lord. I had given to state.
So, but that is our copy. That is my brother's copy.
Yes, my lord. Then that is I'm written.
get it.
দিয়ে দে।
Your lordships are reserving, my lord.
I'm
grateful.
You
Yes,
only
excuse me.
make a short list, and whichever judgments you have referred, give us the paragraph numbers and proposition. Finish.
প্যারাগ্রাফ দিয়ে একটা কাগজ কোর্ট অফিসারের কাছে
আমরা যেমন দিয়েছি
Not
proposition.
landed at সাহেবের থেকে নিয়ে নাও।
Status report is filed by CID West Bengal,
না না
dated 5/10/2023, which discloses that
No, my lord is busy.
repeated futile attempts were made to arrest Kurban Ali Mondal. Full stop. No attempt was made to ascertain whether Any property is there in the name of the Kurban Ali Mondal, which can be seized or attached. No proposition for proclamation. Although the report indicates that he is a proclaimed offender. Let the report be kept in record. First of the report indicates clearly and conspicuously a very sorry state of affairs of the police authorities to nab one absconding convict. Full stop. However, since argument is concluded and the appeal is old one, let it be reserved for delivering judgment. A copy of this order may be sent to the Home Secretary for information and intimation the state of affairs of Police Department. By the Learned Register Administration. Copy of this order may be sent to the Home Secretary by the Learned Register Administration. The তারপরে যে কথাটা বললাম। Mr. Banerjee, this is very bad and very shocking.
Lord, because that's why, Lord, I have tendered my unqualified apology, my Lord. But that will not suffice. It's not, I cannot take the alibi of that. Because I know your Lordship, I know Justice Chakraborty also. Because I'm the last person to play with the court. I'm the last person. That's why I have already, my Lord, intimated him. You kindly ask your officers to talk me at 9 o'clock.
Nothing will happen.
I will convey your Lordship's answers.
Gate.